Any mention?
Please, Your Lordship. Lordship, I beg to make a mention of item number 25, Lordship.
Number?
25. Lordship, I'm praying.
You have objection? Yes. You object to the adjournment? 25?
25. 25.
Yes, yes.
On behalf of
Objecting?
Mr. Day, Mr.
Yes.
Day.
You objecting? Yes.
Your Honor, I have to consult with my senior first.
Don't make the submission. You have the objection to adjournment.
Okay.
Mention after some time.
Yes, Your Honor.
Yes, 25.
Obliged, Lordship.
Yes.
Yeah, please, Your Lordship. I beg to mention item number 23rd, my Lord.
20?
23, 23rd.
23, not 23rd. Yes.
No objection, Lordship.
This matter has been hanging like this. No urgency.
No, Your Lordship.
It's a matter regarding principle, fighting for principle.
No, Your Lord- this is a service matter where we are challenging the post of contractual PGT teacher in KV school, Your Lordship. And there is other matter also with the same parties. It's a posh matter. I think they are praying that it will be listed. It will be listed same date, Your Lordship. My Lord.
What might be different, yes. After 1 week or 2 weeks.
After 2 weeks, my Lord.
Okay. Yes.
Hello, Lordship.
May I please, Your Lordship? I beg to mention item number 24. Praying for 2 weeks time, Your Lordship, in this matter.
Yes.
Obliged.
Yes.
I also beg to mention item number 38, Your Lordship.
But which one? Why are you taking this? Where's Mr. Mahanta?
38.
Were you appearing with?
Mr. Jindal.
This matter has been hanging fire. Why you don't want to close it?
Your Lordship, sir, he's on his way to hospital, Your Lordship. His sugar is a little bit high.
Who?
He's on his way to the hospital because his sugar is fluctuating, Your Lordship.
Okay.
Praying for 2 weeks time, Your Lordship. Much obliged.
Item 36 is pending for last 2-3 years. There is no permanent managing committee, and matter requires urgency. So,
Where's Mr. Kurishi? At least.
and I have already informed him. I have already informed him that that I'll be making a mention to upgrade this matter
Today.
today,
Ready
Lordship.
with the matter?
Yeah. No. I have already informed the Qureshi. I have already informed the Qureshi because there is no managing committee from the last 3
Where's
years.
Mr. Kurishi?
He is in court number 3, Lordship.
Come.
Yes.
Okay.
Highly obliged.
As it is, they'll adjourn all the matters you're hearing. You will come at 11 o'clock.
No problem. No problem. I'll be here.
May I please, Your Lordship? Your Lordship, I beg to mention item number 19 and 20, which are connected matters, Your Lordship. I'm for respondent number 2.
My Lord, we have some objection, my Lord. This matter is ready for hearing, my Lord. Only we have to point out 2-3 paragraph and
She
matter.
has other considerations asking adjournment, not because you're ready or not.
My Lord.
Yes.
Your Lordship, actually,
Not ready with the matter.
not ready, Your Lordship. Because we are not filing affidavit here, Your Lordship, I need to take instruction. What is the stand of the council concerning these
If
issue?
we
Your
are
Lordship?
allowed, my Lord, we'll just simply file our written arguments, my Lord.
Last time, who had made the suggestion that now you conveyed to your people that big suggestion that
My Lord, we have already conveyed, my
Which
Lord.
matter is it?
1920.
Your Honor, we have made
But
submission.
seeking for time, this is not prepared today.
This actually there is nothing left in this matter, Your Lordship.
It is not the
She
case,
has
my
made a
Lord.
submission that as per that they
No,
want.
I understand,
Yes.
but she says she's not ready with the matter today. It's not the court's problem or your problem. It's
No, Your
her
Lordship, it's not
problem.
that, but say
After
that I'm
1
not
week.
ready, Your Lordship, but I just need to
After-
take instruction, Your Lordship. What is the stand of the
My
council,
Lord,
since we are not filing affidavit?
We'll file our written arguments, my Lord.
What weeks is arguments make no serve no purpose. Yes, after 1 week. Yes.
My Lord.
Hello, Your Lordship.
Alleged.
I actually wanted an adjournment, but the learned council has wanted it to be called upon.
Number 4 orders. You let it be called out. Yes.
Yes, that's right. Just one thing, that we are filing an affidavit, if it can be brought on record, my lord.
That we don't know. Depends. The office is slow, so yes.
We will wait, my lord.
Your Lordship, I beg to mention item number 29.
29.
Lordship, this is that matter regarding the DPI compound in Lashimar, Lordship.
DPI compound.
Lordship,
Oh,
in
DPI compound.
Lashimar, Lordship, that extra area that was added after payment of the premium. Then, Lordship, they had.
Okay. Yes.
Your Lordship, Mr. Khalid Khan is leading this matter, Your Lordship, and he's
I never seen
indisposed.
Mr. Khalid Khan appearing in my court.
He's indisposed, Your
This
Lordship.
year, did he appear once also? No.
In this case,
I know in this
Sure.
court number 2, no. So that means here essentially the counsel appearing here only. Correct.
grant me some time, Your Lordship.
Then you prepare the matter.
Your Lordship.
After when?
2 weeks, Your Lordship.
Yes. It's a matter of 2 weeks. And then if only at least argue the matter the next date. Yes.
Obliged, Your Lordship.
Argue some matters. Why?
Supplementary this
Depend
item
on
number
seniors only. Yes.
May I please, Your Lordship?
Yes.
Lordship, here the petitioner is having a bank account with respondent number 1.
Someone, which bank?
Axis Bank, Lordship.
Which branch?
Molai branch.
Molai branch.
Yes, Your Lordship.
What's the money? How amount dispute?
Disputed amount is 5,000, but my whole account has been frozen.
5,000 dispute amount.
Yes, disputed amount.
And is it a salary account or
It's a savings account. He is a daily wage laborer, Lordship.
for 5,000? What to do about these cases? It's become like a disease.
Your Lordship.
Yes, Your Lordship.
Where have you set at 5,000?
Your Lordship, I have
any
got a notice. Yes, Your Lordship. I have got a notice. Annexure 2, page 9.
Your account number so and so have received amount of 5,000.
Yes, Your Lordship.
Dispute of 5,000, 4,1125.
Yes, Your Lordship.
So whole account is frozen.
Yes, Your Lordship. I'm not being able to operate, Your Lordship. I come from a remote area, and this is the only account I have.
So you got notice of 5,426. When did you receive the notice?
We have received in the month of April. It's dated 5 April, but we have got somewhere in April. Thereafter, representations
Yes,
we
sir.
have filed.
Just let someone come from the bank, then we will defease your account.
Yes, Your Lordship.
5,000 is a meager amount. Yes, heard MSP Chetri when it comes to petition issue notice.
I'm appearing for respondent 2, Your Lordship.
Is present and accept notice we have for number 2. Notice to issue to the remaining respondent within 3 days. Just after 2 weeks, yes.
Obliged, Your Lordship.
5,000.
Yes, Your Lordship.
item number 2.
May I please, Your Lordship? Lordship, this matter with regard to the...
Before my learned friend starts, there's a caveat, my lord.
Haripur.
No, my lord. Razawala, my lord. Razawala school, my lord. High secondary school. My lord,
Yes.
here what happened, my
You
lord?
serve copy on the caveat.
Already served, my lord.
The respondent number in the
Respondent 6 and 7, my
Yeah.
lord. President and secretary 6 and
6 and
7.
7.
6 and 7. I think.
6 and 7, my lord.
6 and 7, yes. Lordship, yes.
The
6 and
respondent
7.
secretary and
Caveat petition 53/2026. Stop. Mr. Pinobi Council next time is present behalf of the caveators who have been arrayed as respondent 6 and 7.
my lord.
Limited petition. Caveat stands as charges. Yes.
My lord, here, my lord, what happened? The Razawala is with regard to the legal constitution of the ad hoc managing committee of Razawala High Secondary School on
Yes.
9/6/2026, my lord. My lord, here what happened during during the tenure of the previous managing committee, regular managing committee, there are several allegations with regard to the misappropriation of fund, my lord. Then several complaints were filed. Then 2 writ petitions were filed before this honorable court, and this honorable court directed for inquiry. And after that, my lord, the government respondent authorities, my lord, by order dated 28/7/2025, constituted the special managing committee, my lord, and to inquiry into the matter and submit their reports. After that, my lord, the term of the previous managing committee expired, my lord. Thereafter, my lord, the respondent number 6 and 7, my lord, president and the secretary filed representation constituting 12-member committee without conducting any parent guardian meeting or without passing any
the term
resolution.
got over when?
My lord,
The term of the last managing
my
committee?
lord, the last year itself, my lord.
Last year, then there was an inquiry.
The inquiry,
Then
my
there
lord.
were inquiry detected there was some
Some allegations were there, my lord. Then writ petitions after that, my lord has directed. The writ petition was accordingly disposed of, my lord, in view of the inquiry, my lord.
and direction for new managing committee to constitute.
No, my lord.
No.
No, my lord. Then, my lord, the special managing committee was in existence, my lord. Thereafter, my lord, the file on 25/5/2026 a representation constituting 12-member committee
Was filed by 6 and 7.
filed by 6 and 7.
Whether
my lord.
representation.
My lord, yes, my lord. Annex of 4, my lord. Page 25, my lord.
Yes.
This as per
Prayer by ad hoc committee.
my lord, ad hoc committee, yes, my
Then
lord.
it's not a proper managing committee.
Yes, my lord. Prayer for ad hoc committee of Rajabala Deficit Higher Secondary School for a term of 6 months, my lord.
Yes.
The constituting 12-member, my lord, before the DSEO Tura, my lord. Then this was forwarded to the director of school, my lord, respondent number 3, my lord, for further directions. Thereafter, my lord, the impugn order, my lord, the constituting the ad hoc managing committee was formed, my lord, on 9/6/2026 at page 29, my lord. At page 29, annex 6, my lord. My lord, this managing committee, ad hoc managing committee, my lord, typed copy are there at my lord, page 31, starting page 31. My lord.
It's not 31, it's not, what is it, 31?
My lord, yes, my lord.
Something's wrong, something missing the top.
My lord. My lord,
So there's 31 something else.
my lord, my lord, it is next
please,
page,
you
next
see-
page, my lord.
You see, Mr.
Next page, my lord, 32. It's
Start from here.
Yes, my lord. The whereas
Then
the general
then-
managing meeting for reconstitution of regular managing committee, my lord.
Yes.
My lord, this meeting, this ad hoc committee was constituted, my lord, without conducting any parent and guardian meeting, my lord.
Now this is the term from,
Yes, my lord.
the term was to run
Term, my lord. Term is from, my lord. Yes, my lord. With effect from 9/6/2026 to 9/12/2026 with the following members, my lord.
Okay.
12 members, my lord.
Yes.
Now this, my lord, this committee, without having any meeting, my lord, the parent guardian of the Rajabala schools were waiting after the inquiry, after the, my lord, special committee constituted by the state respondents, my lord. There was no such meeting, no resolutions were passed. We came to know after filing the RTI by one of the parent guardian, we received this order, my lord, impugn order. Thereafter, my lord, what happened on
It's ordered 9 June.
9 June, my lord, yes. We filed complaint, my lord, before the director
Then
and the respondents, my lord. The complaint was still pending, my lord. Complaint at annexure, my lord, 7, page 34, my lord. For immediate action and immediate cancellation of the ad hoc managing committee.
So you just want a new managing committee.
Yes,
What
my lord.
about the allegation you said,
My lord,
inquiry report? Where's the inquiry report? Anything
My
been
lord, that
done
is the,
by the state on an inquiry report?
my lord, those writ petitions were disposed of.
No, but on the base inquiry report, has any action been initiated?
My lord,
by the state
as of now,
respondents?
I'm not aware regarding the actions, my lord, because with regard to
Is
the
there any
state,
recommendations that there is finding regarding some?
some recommendations are there, my lord. But I'm not on that, my lord. I'm on the constitution of the regular managing committee for conducting parent and guardian meeting, my
No,
lord.
responsible body to me.
Yes, my lord.
Yes.
Now the second aspect is, my lord, during this managing committee, but on 6/8, they issued an advertisement, my lord.
Where's the advertisement?
My lord, and the last page, my lord, page 43, my lord. Annexure 10, my lord. May I read?
Page?
Page 43, my lord. Last page, my lord. Annexure 10.
43 or 42? Page 42.
Sorry, my lord, 42, my lord. Sorry, my lord. 42,
Okay.
my lord. 42. 42, my lord.
Absent teacher.
Yes, my lord.
When's the last date for filling the?
My lord, today is the last date, my lord.
Oh.
28, my lord. My lord, before this, my lord, Annexure 941, there's an order by the respondent number 2 that all advertisement for filling up the post of the aided schools, my lord, are kept in abeyance, my lord, because of the rationalization process is going on by the state, my lord.
Yes, Mr. Shlai.
May it please your lordship. Lordship.
Why was ad hoc committee approved?
Lordship, first I would like to.
If there was no managing committee at the point of time, you should have had a regular managing committee.
It's true, your lordship. But first, your lordship, who is the petitioner, your lordship? Lordship, kindly have
Who's the petitioner?
Kindly come to page 6, statement
and one of the
para 1, your lordship. Lordship, kindly have page 6, para 1.
Yes.
One of the parents and guardian, your lordship. Where is the evidence, your lordship, that he is the parent, he is the guardian?
Who's your?
It's only a mere statement, your lordship.
No, my lord. My lord, in that situation, the members who are in the ad hoc managing committee, they are also not the parent and guardian.
No. Now,
my lord, now I am the parent and guardian because my.
No, have you shown a document to show that?
No, my lord,
I am the parent.
No, I have not shown anything because my children is studying in the school, my lord.
Show that studying which class?
Right now, I don't have, my lord.
You know what happened? One earlier case here.
Yes, my lord.
Same question came up.
My lord.
That the petitioner was not a parent or guardian of a child in the school.
No.
And during the course of proceeding, he went adopted one child from the school.
Yes, my lord, I remember, my lord. I remember, my lord. That case, I slightly remember, my lord.
It is your case.
No, not my case, my lord. Not my case, my lord. That is by swearing an affidavit declaring that adopted child and all, my lord.
Yes.
In that case, that is not the case, my lord. I am the one of the parent and guardian. I am the signatory in the complaint, my lord. Kindly have, my lord, page.
Oh, you're signatory in the complaint?
Yes, my lord.
Okay.
My lord, page 36, my lord, Annexure 7, number 2, Rizawul Karim, my lord.
Your number?
Number 2, my lord, Rizawul Karim, Magur Mari.
Yes. Yes, Mr.
There must be.
The locus will keep open.
Well, yes, my locus can be kept open.
Then, lordship, coming to the concern of the money, interim money committee, lordship, can you have page 33?
What is the reason to approve it?
Lordship, kindly have page 33, lordship. That is the type copy. If lordship, kindly have the third paragraph. The ad hoc committee shall extend full cooperation for the conduct of the general meeting for reconstitution of the regular school managing committee whenever directed by the competent, or lordship, kindly see, the ad hoc committee shall conduct the general meeting whenever the situation is conducive before expiry of the term whichever is earlier.
Do one thing, DSU, conduct the meeting, have a regular managing committee. What is there? Everything should be regular.
Lordship, this is only an interim arrangement, your lordship.
Whatever is interim.
Because mostly, your lordship, there are the situation, the atmosphere is not conducive, your lordship.
The last term got over when?
Well, in the last year, I exactly cannot recollect the date, my lord, because in the last managing committee, they fill up the 2 posts.
No,
and after
when expired the last?
My lord,
when is the time
sorry,
when
my lord, I am
between the
that,
expiry of the last term
in the month of
and the ad hoc committee that is going to put in the affidavit.
My lord, in the last October or November, I am exactly not able to recollect the date, my lord, because I am also representing one of the respondent in Jomrul, my lord. My lord, remember the Tomser Ali and the Jomrul, the 2 writ petitions which were one withdrawn and one is disposed of, my
yes,
lord.
Mr. Philaman, what do you have to say?
We can hold a meeting for
the regular managing committee. You take instructions, but
that stipulation is there. It's already there.
We will leave it at that. But this advertisement should be kept on hold.
Lordship, if lordship kindly have a page 41, your lordship, there is a letter of the joint secretary, lordship, to the director that the advertisement.
See, this ad hoc
should be kept in abeyance. So, lordship, so far that advertisement, lordship, yes, lordship, that can be kept on hold.
My counsel for the petitioner, Mr. N.D. Shulai, EAG with Mr. Khan is present on behalf of respondents.
1 to 4, your lordship.
1 to 4. No further
1 to 4, your lordship. Yes.
On the set of respondents. Now you are appearing for principal also, Mr. Nongri. Yes, Mr. Philan Nongri is on caveat on behalf of the 6 and 7. As such, no further notice on these respondents. Notice issued respondent number 5 within 2 days term. Mr. S.K. Sanar, consular petitioner, submitted that The petitioner is a parent guardian.
My lord.
You had earlier come barrier petition.
No, my lord. The other parents were there in the two other proceedings, my lord.
Lordship.
Tomser Ali and Zumru.
Lordship.
My lord.
From these areas.
One will come, your lordship, then he will stop, then another will replace. It's,
because of
this is the
my lord,
happening, your lordship.
My lord, kindly appreciate, my lord. The respondent
will record objection raised by AG.
My lord, yes, my lord.
Lordship, that if lordship kindly have
No,
a page 23, your lordship.
No, we will record your objection.
Lordship,
This is for larger public interest.
My lord.
Yes. No.
18.
It was agreed with the approval given to the ad hoc management committee of
Rajabala Higher Secondary
by
School.
in order dated 9 June 2026 for a period of 6 months. Further grievance is that the ad hoc committee has also floated an advertisement for a recruitment assistant teacher. Stop. They submitted that in fact there's no impediment for the constitution of regular committee and the regular committee, and that the respondents, instead of taking steps for reconstitution of the management committee, and in spite of a complaint being filed on
My lord, on
23rd June 2026.
My lord, yes, my lord.
They have
23rd June, my lord.
action. Stop. Further praise that in the interim the advertisement dated 6 August 2026 bracket Nexhatan Ripton be kept in abeyance. Next permit and Shulai then AG appearing for the respondents 1, 2, 3.
4, your lordship. Lordship, yes.
Has raised an objection with regard to the locus of the petitioner and submits that no materials have been given to show whether he's a parent or a guardian, and on this count the petition is not to be entertained.
Lordship.
However, with the larger question, it is submitted by letter AAG that the instructions will be sought, and that as it appears there are orders from the state respondents with regard to absence of post, the impugn advertisement may be kept in abeyance.
Lordship.
Yes. Mr. Philonomri appearing for 1, 6 and 7 submits that these respondents are ready to facilitate the meeting for reconstitution of the management committee. Stop on the same note. Upon hearing the counsel for the parties, that instructions be received by the learned AAE. In the meanwhile, the advertisement dated 6 August 2026 shall be not be in effect to the next date. Yes. Just after 2 weeks. You get instruction, then
Lordship, yes. Obliged, your lordship.
3. Item number 3.
May I please, lordship?
This is freezing this one. Which bank is this?
Lordship, SBI Bank, lordship.
SBI, which branch?
Ranikot branch, lordship.
Ranikot branch, you appearing for whom? MSM?
Respondent number 1 and 2.
1 and 2 is state.
Yes, your lordship.
Yes. This is from Uttar Pradesh company.
Yes, lordship. Notice was issued.
Money you have in your account?
Lordship, 3 lakh, lordship.
3 lakh?
Yeah, disputed amount is
1.5 lakh disputed amount.
Disputed amount is 1,50,000, lordship.
You've already used it also.
Because, lordship,
you don't know.
Petitioner is not aware
where the money came from.
Yes, lordship. After freezing only she came to know.
But there's still money in your account.
Yes, lordship.
Yes, her Mr. Amar Marak, the constituency issued notice, MSADCM, except on behalf of respondents 1 and 2. No further respondents don't issue the remaining response within 2 days. Yes. just after 2 weeks for the orders.
4.
But we have filed this application with the disposed of matter, my lord, for slight modification of the order.
Yes. Is MS
Yes, madam.
Bugle is there?
Yes, madam.
Yes.
Yes.
Is a copy of the miss case?
I am not really opposing, but there has been certain developments which I thought should be placed before this honorable court. There has been a writ appeal by the private respondent.
There has been a?
There has been a writ appeal by the private respondent, and that appeal has been disposed of with a direction that if the private respondent chooses, may approach this honorable court by way of a review application. And till then, because there was a miscase and we considered that there is already a miscase, we are not opposing to the extension of time till 31st August. So the division bench also said that okay, till 31st August there is a status quo.
What is the order? Then your miscase is.
Yes, if this miscase, if it comes on Monday, madam.
The petitioner in the writ petition.
Mr. Carlindo.
If it comes on Monday, my lord.
Where is that? Where's that original writ petitioner?
Original writ petitioner.
I am
sorry, respondent. Sorry. Yes. You served him?
Not served, Carlindo. We have not served. Why the matter comes on Monday because the division.
Do one thing. You served miscase to him also.
Because DB's timeline is also till Monday, madam.
Yes. Click on miscase. Miscase number
234.
30. So in so and so. By this application, modification is sought of the order dated
7/8/26.
7/8/26 to allow for extension of time up to 31st/8 before the contract with the private respondent is annulled. Dr. Mozika, whoever today, has also brought notice of the court a decision of the writ appeal dated 26/8/2026, which has since been preferred by the respondent. This private respondent, wherein directions have been issued that the status quo be maintained till 31st August.
Not till 31st August, it is still filing of the review or 31st August, whichever is earlier.
Yes. Which is shall remain in force till final review application or till 31st August 2026, whichever is earlier. As the counsel of the private response not available today, just a matter on Monday. Yes.
Grateful.
5.
Yes, Mr. Shulai.
Lordship, may it please your Lordship. Lordship, this is our application for transfer, your Lordship.
Present, yes.
Lordship, in my humble and respectful submission, your Lordship kindly have the ground of transfer, your Lordship.
Are you filing the affidavit? No.
No, your Lordship.
When the next case, Mr. Bora?
Lordship, yesterday, day before yesterday was a date, Lordship, the PO was on leave. We have no information about the next day.
You look up in the CIS, you must be there.
If Lordship kindly have a para 9 at page 7 of the transfer application, your Lordship.
Status was sought for the FIR, Lordship.
Lordship kindly have page 9 para 9 page 7 para 9, your Lordship.
Whole matter.
Lordship, yes. Lordship, these are the ground of transfer.
The cool matter. Page 9.
Yes,
page 7 paragraph 9, your Lordship. A. This is only a ground of transfer, your Lordship. His own. Then in Crown B, your Lordship, he said that there are business rivals. Then he is scared of his life, your Lordship. Lordship, for this, your Lordship, in my humble and respectful submission, could not be a good ground for transfer, your Lordship. The petitioner can have recourse to section 228 of the BNSS, your Lordship.
What section 228?
Lordship, if Lordship kindly have BNSS.
Let us see, what does it say? No, I'm
Lordship,
totally unfamiliar with these provisions.
Lordship, I am also Lordship. If Lordship kindly have 228, your Lordship.
Read it out.
Lordship, this is a dispensation with the personal attendance of the accused, your Lordship. He can take recourse to that, your Lordship.
You can take this ground before the
Lordship,
court
yes, he
there.
can take recourse to that, your
Justification of
Lordship.
personal appearance.
And if Lordship kindly have for the moment, if Lordship kindly,
Yes.
if Lordship kindly have the charge sheet that
What's the status of the case now?
Lordship, it has been charge sheeted, your Lordship, during the course of the investigation, your Lordship. This applicant, your Lordship, remain absconded, your Lordship kindly have page 28, your Lordship. This is the brief fact of the case, your Lordship. This is the charge sheet.
No, we're not going to go to that. Yes. Today, Shulai submits that, or Mr. Bipu Gura, for the petitioner, submits that he's not aware to when the matters, when the next date, is not aware of the next date.
Not aware of the next.
The next date when the matters which stop. Mr. Shulai has submitted that the grounds set out in the application for transfer do not constitute substantial materials to warrant the same. He further submits that if the petitioner is stated to be old and having back issues, they can take recourse to section
228, your Lordship, of the BNSS.
For consideration.
Lordship will not take up for disposal today, Lordship. I'll be physically present. Lordship, I'll be physically present. I thought that today, for the status of the
Okay, then you come personally. Yes, Mr. Vivro submits his way of
Lordship, any objection may be filed.
Next date fix, yes. Mr. Andy Shulai submits that no grounds have been made out for transfer. However, Mr. Bipora prays that the matter be heard so that he can appear physically. Yes.
Lordship.
Just after.
Yes, Lordship, any objection, if any, may be filed, Lordship.
Yes.
That will be on record, Lordship. I can reply adequately.
Court also permits the Elan AG to put on record any objection.
Lordship.
For the next date, just after 2 weeks. Yes.
Obliged, Lord.
Deeply obliged.
Deeply obliged. Just now, anyway. Yes.
Lordship.
Daily list item number 1.
Lordship, so far the state is concerned in this writ petition, your Lordship, there is no relief claim against the state, your Lordship. Lordship, the main relief claim in the writ petition is pensionary benefit, your Lordship. Pensionary benefit, your Lordship, to be paid to the writ petition, your Lordship, it is not the financial responsibility of the state, your Lordship. Lordship, the discouncil, they have their own act, your Lordship. They should generate.
You're seeking recall. You want to repeal the act. It's already repealed.
So they repealed
the affidavit.
They have filed an affidavit, your Lordship, bringing on record the repealing act.
Then. So what should we do then? What amounts are pending? You have to challenge the repealing of the act then.
Your Lordship.
What amounts are due still?
Your Lordship, it's in lakhs, your Lordship. It's it keeps on accumulating, your Lordship. Your Lordship, in the
how many petitions are here?
Lordship, there are 23 writ petitioners, your Lordship.
Lordship, in the petition, I have annexed the amount which is due to the petitioner's page 82, your Lordship.
That was when the petition was filed.
This was when the matter was filed last year, your Lordship, and that was in lakhs.
Only one thing with regard, okay, till the repeal of the act, you will have that they will have to be paid that amount.
Yes, Lordship, but we are paying them, Your Lordship, from time to time. We cannot clear.
No, Your Lordship, if you would see the order, order of 23/3/2026, Your Lordship, the respondent council, district council, they had informed the court that there is some consideration for disbursement, and later they informed the court that they have. And they did not come before the court, Your Lordship, whether funds have been released by the state government. For that reason, Your Lordship, I'm pleading the state government if they can bring anything on record to show that whether amounts have been released.
Your limited things only whether the whether funds have been released for pension for this
Lordship,
separate head.
if that be the grievances, your Lordship,
One thing,
Council
like,
should
suppose
Lordship,
you release the funds, you release the separate heads, or is it lump sum?
Lordship, this
share
council
of
has no grievances, your Lordship.
No
So far
grievance
that
against you,
that issue
yes.
is concerned, your Lordship. If they have any issue with the state government, they should come, your Lordship. They just should come, your Lordship.
Whether separate funds are allocated or whether.
Only one thing is that you just come next date, just give the calculation of
Your Lordship.
what will be
Till
the
date.
total amount, individual and total amount that, till the act has been repealed.
Your Lordship.
But that is the due, that cannot be denied.
Your Lordship, as
Maybe
far
even a
as
minor grant interest, but at least what you should get, How much? 5,000 a month?
5,000 a month is the small amount, Your Lordship. And for those who are CM and EM, more than 2 terms, it will be 8,000 maximum per month. And most of the petitioners are suffering, Your Lordship.
2019. And be a huge.
Petitions are 2 times MDC or 3 times?
Most of them 2 times, Your Lordship.
Yes, Mr. Andy Shulai today has had an appearance today, first time.
Lordship.
On behalf
This
of
is
the
this
newly
campaign.
impleaded respondents.
State, your Lordship.
Respondent number 5.
Number
5, your Lordship.
newly respond number 5, yes, and submits that no reliefs have been claimed against the petitioner, nor have the as a council respondents approached the state in this regard. Stop. As it is reported that the pension, what's the act called?
Lordship, the act, Lordship will find at page.
Is the Khasi KHADC bracketed members
What
pension.
report? Yes, that the
page 19, your Lordship.
The Khasi Hills Autonomous District Council, then within
bracket members pension act 2002.
Pension
Bracket,
repealing
your Lordship. Act 2002.
Repealing Act 2006 received the assent of the governor on 21/5/2026. As reported that is also members pension repealing act has received the assent of the governor and as such stands repealed. So the only question that remains in the instant writ petition is regard to the undisputed amounts that are due to be released by the council on the stop. On this count, MS paragraph MSPS Nongri appeals funds 1 to 4 pays without obtaining instructions. Top MSB of Karonlang for the prince also pays allowed to bring a chart to indicate the exact amount that is due till the
repealing of
repeal of the act. Just after 2 weeks.
Highly obliged.
Highly obliged, Lord.
1 and 2 are connected to it.
You just make a chart of the amount with each MDC and all that, right?
Yeah, Lord.
Yes.
3.
May I please, Your Lordship. Lordship, I'm praying for 2 weeks' time to file rejoinder.
How many times you?
This is the second time, Your Lordship.
Second time as prayed for the 2 weeks time, allowed for rejoinder just thereafter.
Obliged, Lordship.
4.
One and two, my lord, we'll file a small affidavit to bring on record the timeline.
Yes, Mr. N. Khera is under the appearance on behalf of 1 and 2 and is allowed 1 week's time to put in an affidavit. Yes, just thereafter.
5.
Obliged, my lord.
Yes.
Lords, in this matter, I have been informed, my lords, the corporation has, my lords, decided the issue. The representation has been decided. A communication has been issued, my lords. I am praying, my lords, allow me to bring it on record, my lords.
You already allowed that last time.
Yes, my lords. The instructions have been relayed to us only, my lords, yesterday. In respect of, my lords, the communication.
Further 2 weeks time.
Yes,
order dated 6/7/2026. This court had allowed the respondents 2 weeks time to to put instructions on affidavit with regard to the sanction of the pension and other benefit stop. 2 days further time is prayed. In the interest of justice, further 2 weeks time is allowed this.
Hello.
6.
Your Lordship, we have reinstated the suspended chief, Your Lordship. This is a reinstatement order.
Yes. What is this matter about?
This is no longer in SIMship.
Appointment of
Acting
CM matter.
Okay.
Lordship,
Yes.
this is the order.
Lordship, let this matter come after 2 weeks. I need to get the confirmation from the.
Sorry, Mr. This is officer government.
I must.
You need to get material instructions. That's at your own accord.
I can give him a copy now.
No, he needs other instructions. Yes.
Just 1 week.
MSPS Longbury has produced a communication dated on order dated 15 July 2026 that shows that the regular CM facility is dated. In the view of the matter, nothing suffice consideration, and the incident is disposed of. The order dated 15 July 26 is taken on board and made part of the record. How you going to prolong?
I've been instructed that I just need 2 weeks. That's it.
Dispose of, you tell them.
7.
Yes.
7.
No. Same order.
Same order.
8. Item number 8.
This is that matter, my lords, where an application has been moved under section 152, my lords. And
Yes, Ms. Bla. What is this?
We've received the affidavit filed by them, Your Lordship.
What's the affidavit say? Objections to what? Both objection on what basis, Mr. Sen? Mr. Pandey?
Yes, my lord, I am just coming, my lord. This is only some, my lord, inadvertent error, your lordships. The contention before this honorable court only issue to be decided, my lord. I am a lecturer in Shillong Polytechnic. AICT has been extended to me. AICT, my lord.
No, the objection they filed. What do you have to see in this?
Yes, my lord. That objection, my lord, they are saying, my lord, this has a bearing on UGC. There is
you
no
to file any short reply.
No, not required, my lord.
Yes.
I will just argue the case. Now, my lord, read petition. Now, my lord, the only issue.
What's it for today?
Today is for that correction, your lordship. This
correction, no?
Correct. There are some, my lord, inadvertent error, my lord.
Oh, yes, in the order.
In the order. In fact, your lordships, when this matter, they have filed an appeal. So, in course of appeal, my lord, I consider this has happened inadvertently. And my lord, court has, in his presence, my lord, my learned friend, court has passed an order. If I can take my lord to that order by the division bench.
This is in the application.
In my application, my lord, at page 21, annex 2.
At page 21.
21. Yes. If I can read it, your lordship.
Yes.
During the course of argument, Mr. Pandit, learned counsel for the appellant, submit that the learned single judge has dealt with the provision of UGC. The said submission is countered by Mr. Sen, learned counsel appearing for the respondent number 1. He submits the reference of UGC provision was inadvertent and he intended to file an application for seeking to minute necessary correction. However, in the meantime, the aforesaid appeal came to be filed. He stated that since the learned counsel for the appellant is relying on the observation recorded by the learned single judge vis-a-vis UGC regulation, he will file an application before the learned single judge for speaking the minutes and for deleting the reference of UGC
Speaking
provision.
to the minutes mean?
Minutes means, my lord, that's...
Speaking to the minutes?
My lord,
first time I've heard this kind of term being used.
My lord, I think, my lord, that narration, my lord, whatever is narrated in the judgment, that's my understanding. Now, my lord, the issue is very simple. What issue as lordship was called upon to decide, and my lord, AICT was extended. If I can take, my lord, to set the confusion, I have annexed the AICT regulation also, my lord, in the writ petition. If your lordship take up the writ petition, my lord, at page
1 second.
67.
What did he say in the objection? Why is he objecting to the?
My lord, there is, my lord, nothing at all.
Because if I may sub-
No, if let me, my lord, complete.
Yes.
At page 67, my lord, of the writ petition. Lordship has got it, my lord. Now, this is the regulation I do. This is dated, my lord, 4th January 2016. Now, this is a regulation notified by AICT. Now, my lord, here the concession was granted to the reserve category. Next page, serial number 4.
Yes.
My lord, it's a consideration on the undermentioned issues, purpose for appointment of various teaching post, degree, diploma, relaxation on minimum passing qualification against backlog vacancies, relaxation to SC, ST. Now, my lord, they have clarified in the next column, my lord, rule relating to reservation of respective category, including relaxation in the minimum qualification criteria of the concerned state central government shall be applicable. The relaxation as provided by the state government shall apply. And state government file an affidavit. They said 5% relaxation is available. So 5%, they have said 5% relaxation as provided in AICT is available only in the entry stage. So my contention, these will apply also in the promotion stage.
Yes.
And my lord, after hearing me referring to all the regulation, my lord has held, yes, not only in the entry point, all the stages it will apply. Now, my lord, if I can take your lordship to the judgment for correction. Lordship will kindly come to
Miss Case.
Miss Case, my lord. Correction. 2 and 6, my lord. 2. First I will take my lord to 2 at page 12.
2.
Yes. Mrs. N. London Council for submitted that the letter concerned in direct conflict with notification dated, just now I have read it,
Yes.
4/6/2000, that is a AICT notification, my lord, which had been issued by UGC. That's wrong, my lord. That is AICT, lordship. It has happened inadvertently. I don't know why he has objection, your lordship. Now, my lord, coming to para 6.
Yes.
6 what? Which one? Para 6. Now, my lord, para 6 again, your lordship. On hearing the London Council, the only main issue in the opinion of the court is whether the relaxation allowed 5% by the UGC. Now, these 5%, though it is not mentioned in AICT, I will just take my lot to the affidavit filed by the state government. State government has said the 5% relaxation available, my lord, under AICT shall apply only in the entry level, not for the promotion. So, my lord, this is a mistake, my lord, happened inadvertently. Now, so far, my learned friend in the objection.
No, also, see, Mr. Pandey refers to by the UGC and has given SIT regulation. Anyway.
Yes. There is a correction, and he is objecting. Other ground he is taking, my lord. Just let me clarify.
Yeah.
He is saying in my synopsis, my lord, inadvertently UGC has come in 2 places, your lordship. I remember. But in the writ petition, no way UGC, my lord. And I have relied on a decision of the Supreme Court just to show the court, my lord, where the Supreme Court has held. Once the state government adopt UCC regulation, my lord, they cannot rely on part of it. They will have to follow the whole of it. So I say my submission was, my lord, even in case of AICT, which is a central government regulation, if the state government adopted, they will have to follow the reservation also provided by the AIC. That was my contention. But my lord, that was not challenged by the state government, that it will not apply. So my lord has not gone into that issue. So my learned friend in the objection, he is relying that I have referred to a judgment relating to UGC. So these are the 2 corrections, my lord, required to be made.
Yes, Mr. Pandey, what do you have to say?
2 things. Because firstly, if your lordship has the paragraphs which are being sought to be modified, my lord's paragraph 6.
Yes.
State affidavit.
Your lordship has the application, and in application, my lords, first is paragraph 2. I apologize. Paragraph 2. Paragraph 2 is the submission of the learned counsel, my lords, and it says that Mr. So-and-so for the petitioner has submitted that the impugned letter comes in direct conflict with the notification dated so-and-so which had been issued by the UGC in connection with the technical education. So, my lords, firstly, the submission was made in respect of the UGC, and it was I will prove that, my lords, this is not an inadvertent submission. It was a conscious submission made that UGC provides this relaxation, therefore this relaxation should also be granted to the petitioner. And due to this submission, Milots, read with other materials which I will just highlight, Milots, para 6 comes, para 6 of your Lordship's order. Because I was perplexed, Milots, how come the UGC is mentioned in the order when UGC has nothing to do with this case, Milots. Para 6, kindly sees para 6, Milots.
Yes.
Para 6 is on hearing the learned counsels or for the parties. The only main issue in the opinion of this court falls for adjudication is whether the relaxation allowed of 5% by the UGC and an important word is and as given in AICTE. So the submission was towards drawing an analogy between UGC and AICTE. That is the reason why there is a use of the expression, and the UGC provides an exemption, the AICTE provides analogous exemption, and therefore that ought to be given to the petitioner. Milords, now in this light sees, Milords, my objection.
Yes, what do you say?
Milords, my objection at your Lordship, my all objections are incorporated in para 11.
Yes.
Yes, Milords. A, the reference to UGC in paragraphs 2 and 6 of the judgment dated 15 September 2025 is not because of any accidental or clerical slip, which is the only thing allowed under section 152 of the CPC. The said reference is only because of the specific submissions made by the petitioner during the course of the hearing. The submissions of the petitioners were aimed at drawing an analogy between UGC regulation and AICTE regulations. It was specifically said that because the case of the petitioner falls within the UGC regulation, therefore the petitioner ought to have been granted the relaxation of 5% marks even at the stage of career advancement. The AICTE regulations do not provide for any relaxation in the marks as is done by the UGC regulations. A stark difference exists between both the regulations. However, the petitioner submitted that since the case of the petitioner is covered by the UGC regulations and therefore he ought to be granted the relief. Now, let's kindly see the quoted portion where the synopsis is quoted. This is petitioner synopsis. In the circumstances, the writ petitioner having obtained 55.25% of marks at master level qualifies the UGC norms to be eligible to draw AICTE pay scale as well as promotion under the CAS, including incentives for higher education provided under the AICTE regulation. Thereafter, Milords, the quoted part, the highlighted part in the second at page number 6, in any case, the subject education belongs to the concurrent list, and in any case of conflict between the central and the state law, the central law would prevail. As regarding the binding effect of the union law in the matter pertaining to education came up for consideration between the Honorable Supreme Court, and it has been held that state having extended the UGC regulation is bound by it, and if any, the state law runs counter to the central law, the same would be held repugnant. A judgment is, Milords, quoted to that effect and annexed with the synopsis. So a submission was made because the UGC provides a relaxation that ought to be implemented. If you are not doing so, you are running counter to the central law, and therefore, Milords, that is impermissible in law. Now, Milords, point number B. Even during the hearing, Milords, which is available online, of 4th September 2025, available online, the petitioner through its counsel placed reliance upon UGC regulation being adhered to after its adoption of the state. By the state, it was submitted that if UGC regulations are adopted, then the state government and it cannot deviate from that. For this purpose, reliance was placed on the Supreme Court judgment, Milords, 2022 5 SCC 179. The petitioner also placed reliance upon Article 255 of the Constitution to say that in case of any conflict between the central and the state law, the central law will prevail, and as such, education is a matter of concurrent list and any repugnancy will be decided in favor of central law. Thus, it appears that it was projected as if the UGC scheme would be applicable to the facts of this case, including the relaxations thereunder, Milords. Now, kindly sees, Milords, why this is important. The UGC regulation at point number C. The UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities of 2010, my lords, specifically provides in regulation 3.4.1 that a 5% relaxation will be available at graduate and master's level for a 5% relaxation to scheduled tribes, scheduled castes, and below so and so categories for the purposes of eligibility and for assessing good academic record during the direct recruitment. And Milos, this is the quotation from the UGC 2010 regulations. AICT also passed a 2010 regulation and UGC also passed a 2010 regulation. A relaxation of 5% may be provided at the graduate and master's level to SC, STs and differently abled for categories for the purpose of eligibility and for assessing good academic record during direct recruitment to teaching positions. Milords may kindly note there is no discretion provided in the UGC regulations. And over the page, Milords, at point number D, Milords, the AICTE regulations are discussed, which provides a discretion to the state. Unlike the UGC regulations of 2010, the AICTE regulations AICTE technical regulations for teachers and other academic staff of technical institutions 2016 do not provide for any categorical relaxation, rather leaves it to the rules applicable in the respective state. Even otherwise, the clarification only deals with appointment and not CAS. Milords, at page number 10, the AICTE regulations are quoted.
Yes.
And it says, Milords, it says that consideration, the right hand side, rules relating to reservation for respective category, including relaxation in.
Yes. Yes.
So it says, Milords, rules relating to reservation for respective categories, including relaxation in minimum qualifications of the concerned state UT central government as applicable would from time to time would be applied. So rules relating to the of the state. So if there are any rules, then they will be applicable. But the UGC provides, Milords, a blanket relaxation of 5% irrespective of any rules framed by the state. Therefore, Milords, the Supreme Court said that once the UGC has taken a call, that would be applicable to all concerned, all faculty. And that was not the case of AICTE. So, Milords, in that light,
so what you're submitting is that AICTE scheme differs from UGC. UGC is blanket, while AICTE gives the state some amount of elbow room for discretion.
Yes.
To mean qualifications and promotions. That's the only thing as applicable. But by as applicable would mean what? Would mean as applicable as we've been going down, which is in practice, or whether it gives the state the what called the discretion to decide case by case. What will be the definition?
The definition will also be exactly how the clarification puts it, that the state
we have to
government
interpret that now, because as per your submissions now, this judgment cannot be implemented, because now in view of the application that I put in AICTE. So if that comes in as per your submission, then the whole complexion changes. That gives the state respondent some leeway to maybe not grant the 5%. I mean this relaxation in promotion. That is the only. That's your submission, correct? I understand correctly.
That is my that is my submission, Milords.
And the second part is that this review will not be. I mean, this correction will not be maintained because it changes the entire structure of order. That is the thing.
Yes, that is the thing, Milords. So, as
so
far
for
as
5% is concerned, my lord, that is considered in paragraph 12 of the affidavit. What the paragraph 12 of the state affidavit says, that in reply to the amendment 12 of the writ petition, it is reiterated the relaxation of minimum qualifying mark of 5% for the purpose of appointment as per point affidavit filed by the state government in the writ petition.
Milords, if I may complete and then
just let him complete. Let him complete, then he can reply.
Yes, Milords. So, Milords, for the AICTE, they have to, the government has to frame rules and say that we are implementing the 5% relaxation, and thereafter, Milords, the relaxation would be applicable. That is Milords, the distinction between the UGC and the AICTE. This is, Milords,
understood. Yes.
Yes, ma'am. This is without prejudice to the point that comes thereafter, Milords, point E. Point E, which is there, Milords. Thus, the AICTE, in my reply, the AICTE scheme differs from the UGC scheme. The UGC relaxation and AICTE relaxations are at a different footing, and the mandatory nature of the UGC relaxation in the UGC is inapplicable to the case of AICT for appointment inasmuch as the AICT only falls back to the rules of the respective state government. If the concerned state government does not have any rule for such relaxation, then the same would not inure any benefit to the candidate concerned, my lords. Here, my lords, a point to be noted is that all of this argument would only be applicable if we say that these relaxations can be stretched to promotion. Because
that is what. So, what is the practice now? If relaxations are given across the board, I mean promotions also, or whether that's what this court's asking, whether it's examined on a case to case basis, or what are the rules operating as far as states concerned?
In fact,
if that flexibility has been given to you, as per your submission.
Well, this specific query was posed also by me to the department, Willots. Upon that, I have received, Willots, instructions that there are no rules for relaxation frame. So we are not giving any relaxation. We are insisting upon the faculty to at least acquire 60% of marks. They be having first class and thereafter.
Is this matter under appeal now? Yes, my lord.
Yeah, appeal is pending.
Appeal is pending. Only that correction question of UGC, there I concede, my lord. Inadvertently it happened. So far 5%.
From the submissions, there is some merit submissions also. UGC be blanket, they are bound, become mandatory. Now if AICTE norms are put in, and if we are going to apply that correction to AICTE, then maybe it'll have a different impact on your case.
Lordship will go by the pleadings made in the writ petition.
Also will be
pleading in the writ petition. If your lordship kindly take up the affidavit filed by the state government, page 11. Page 11.
Just before my learned senior begins, I have two Millots authorities on this issue. One recent authority. If my learned friend can hand over the recent authority in the case of Flipkart of the division bench, and this is a judgment of the Delhi High Court, which quotes the Supreme Court judgment of 1999.
Yes, which part?
Yes, Manoj, just a moment. So, Milords, in this judgment, kindly sees, Milords, this is an application, first paragraph, under section 152, read with 151 of the CPC, seeking clarification of judgment of 10th April 2026. The learned senior counsel for the appellant submitted that the judgment records at the time of pronouncement of the judgment on 10/4/2026, whereby the appeal was dismissed and the order dated 12/11/2018 was vacated, it was submitted on the behalf of the applicant that a reasonable time may be granted for complying with the interim injunction. It is further submitted on behalf of the appellant that the said submission has been inadvertently incorrectly recorded, as in fact submission made on behalf of the appellant was to grant time to avail legal remedies. Accordingly, it is prayed that para 26 of the judgment may be modified. So, Milords, that was the submission. This was opposed, Milords, in paragraph 4 and 5, Milords, and then 6. Having considered the submissions made on behalf of the parties, it is observed that at paragraph 26 and 27 of the judgment correctly recorded the submissions made on behalf of the parties, and accordingly this court has granted time for complying with the interim injunction. Although the learned senior counsel of the appellant has submitted that the submissions are not accurately reflected, this court is of the view that the such submission cannot be accepted. Accordingly, no case has been made out. Milords, kindly cease thereafter point 9. Point 9, Milords, from this point, there is a discussion on the law. At this juncture, the learned counsel of the respondent submitted that the above observation is not permissible in view of the fact that the application preferred by the appellant under 152, read with 151 of the CPC, is not found to be maintainable. Now, Milords, kindly seize 152. Clerical or arithmetical mistakes in judgments, decrees or orders or errors arising therein from accidental slip or omission may be at any time be corrected by the court either on its own motion or through an application for any of the parties. This, my lords, was as explained in Dwarkadas versus State of MP, quoted thereafter.
Yes.
Section 152 of the CPC provides for correction of clerical or arithmetical mistakes in judgments, decrees or orders or errors arising therein from any accidental slip or omission. The exercise of this power contemplates the correction of mistakes by the court of its ministerial actions and does not contemplate of passing effective judicial orders after the judgment, decree or order. The settled position of law is that after the passing of the judgment, decree or order, the court or the tribunal becomes functus officio, and thus being not entitled to vary the terms of the judgment, decrees and orders earlier passed. The corrections contemplated are of correcting only accidental omissions or mistakes, and not all omissions or mistakes which might have been committed by the court while passing the judgment, decree or order. The omission sought to be corrected which goes to the merits of the case is beyond the scope of section 152, for which proper remedy for the aggrieved parties to file appeal or review. It implies that the section cannot be pressed into service to correct an omission which is intentional, however erroneous that may be. It has been noticed that the courts below have been liberally construing and applying the provisions of 151 and 152 of the CPC even after passing effective orders. No court can, under the cover of said section, modify. So, this judgment holds field till today, and it has been applied by various courts to to correct mistakes which are only accidental slips. And in this case, it is my humble submission, those
it's not accidental.
It's not accidental.
Yes.
Yes.
The last one. Very warm. Yes, Mr. Zen.
Yes, ma'am. No, my lord, the judgment, paragraph 6, it says correctly recorded. Here, whole my case is, my lord, is not correctly recorded. Now, 4-1.
No, one thing, Mr. Sen, you have to
my lord, if
answer,
you can, yes.
The one biggest obstacle is that the judgment was rendered not on any misconception, but on the submissions made by you on synopsis and on oral arguments. Correct, and on placing of the relevant whatever statute. So now, if that was placed, the whole complexion of the case changes in the sense that if UGC, as this court understood, that 5% relaxation, it's applicable down the board, and the state has no say. Now that is why this court was held that fine, since 5% was relaxation given at the initial stage, that 5% should apply when you consider for promotion. Correct? You don't have that 5%. So the relaxation, whether it carries on or not, if under UGC rules, then there's no question. But if it's under AICTE regulation, now whether the question now arises whether that relaxation can be given to you if the state been given that the discretion with regard to application, or so that is the only thing that
exactly.
And that amount of review now.
Exactly, man.
So the thing is that we cannot entertain this application like simplest like only for correction of the clerical order.
I'll clarify.
We will permit you to file a review.
No, my lord. I'll just correct. If your lordship do not agree, other way. Now, first in paragraph 2, what is my contention? Lordship has said relaxation as provided in notification dated 4/1/2016 by the UGC. Now, my lord, this is annexed at page 68, your lordship, 67, 68. What I have annexed, my lord, and relied on is a notification dated 4/1/2016 of the AICTE. Is it not a, my lord,
That has been clarified.
My lord, is it not a, my lord, lordship will kindly come, your lordships, page 67. Page 67 is the AICTE notification. No, I have not annexed any UGC notification in my read petition. Kindly come to lordship page 67. Of the read petition. Lordship has got it. This is.
Yes.
Yes, my lord. All India Council for Technical Education notification dated 4 January 2016. And next page, my lord, at point number 4, it provides that the reserve category, as per, my lord, in the next column, are as per the state policy entitled for relaxation, whatever is available, my lord.
See, the thing is that, come back to the judgment.
My lord, I'm just coming back.
Yes, just one second.
Yes. Now, what your lordship, my lord, what your lordship has...
matter unnecessarily.
No, my lord.
See.
What your lordship has recorded.
Recorded here.
Yes, my lord.
Where is it?
At 2.
Yes.
At 2.
Issued by UGC.
Issued by, my lord, it's never been issued by UGC. It's issued by AIGC, my lord. AICT at page 67. I have not annexed any regulation of UGC, my lord, in my report.
Come to your synopsis then. Because we depend assistance rendered by the council.
No, my lord, I'm sorry, my lord.
The assistance rendered and correction is sought by blaming the court that this material was there.
I'm not blaming
it was not appreciated in the correct manner. Then I'm sorry, we are incompetent or whatever.
No, my lord, I'm sorry. It's not that is what all I'm saying, my lord. I'm sorry, my lord. For my synopsis, I'm sorry.
And the court does see it as recorded, and it's only one synopsis, and that is.
My lord, in my synopsis at page 7, your lordship, in the circumstances, writ petitioner having obtained 55.2% down master level qualify UGC, my lord. I should have mentioned AICT norms
then
to be eligible, my lord. That I consider, my lord. And this is not, my lord, whatever it may be, I should have assisted properly, my lord. This is not what is pleading, my lord, what is stated in the writ petition and what is stated in the affidavit. Now, my lord, regarding other, my lord, correction, my lord, at paragraph 6.
And you see this at page 8, second last paragraph.
Which one, my lord?
In your synopsis.
My lord. Paragraph 8. I have relied, my lord.
That 8,
yes.
And page 8 of your synopsis, second last paragraph.
Yes.
As regarding binding effect of union law and matter pertaining to education, came of consideration for the Supreme Court, has been held a state having extended UGC regulation is bound by it. And if any of the state law runs counter something, the same would be repugnant.
Exactly, I said.
Correct.
I said, why you know what context?
Right. So that if
no, my lord.
Court yes,
no, what?
That this is a UGC regulation allowing 5% relaxation, and so the court bound. So the order would come accordingly.
No, this judgment, why I have relied in this judgment, just to show, my lord, to your lordships, that in this judgment the court has held, one, the state government applied, my lord, the UGC regulation. Then the Supreme Court said, my lord, you cannot apply only part of it. You apply whole of it, and your regulation, state regulation, should not run contrary. So my submission was, AICT being a, my lord, sanitary regulation, my lord, same ratio will apply. Only for that purpose, but that issue was never raised by the state government. State never, my lord, disputed that the AICT regulation will not apply. Now, if I can take my lord to paragraph 12 of the state affidavit.
We arguing the whole matter, Mr.
No, my lord, state affidavit, my lord. Short one short paragraph, my lord. Paragraph 12, page 11, my lord. That. Yes, my lord. That in reply to the amendment made in paragraph 12.
Affidavit 1 to 5. Affidavit
12.
Yarkhan.
Yes, 1 to 5. Yes, 1 to 5 and 8. If I can read, my lord, that in reply to the amendments made in paragraph 12 of the writ petition, it is reiterated that the relaxation of minimum qualifying marks by 5%, they are not disputing 5% is available, for the purpose of appointment as per point 4 of notification of AICT dated 4/1/2000 cannot be mixed with the requirement under CAS. So their contention entry level, it is permissible. When it comes under promotion, that is the only issue lordship has decided, nothing else.
Exactly.
That is
now by what was held was that under the impression UGC regulation. Now what they brought up is that is AICTE, which gives that state the latitude whether to
My lord, they have considered that 5% twice, not only once. 5% they have said it here, my lord. Again they have said the same thing in paragraph 6. Lordship will kindly come to paragraph 6
of the affidavit.
Of the same affidavit. That the petitioner in paragraph 6 of the writ petition is mixing up the provision with respect to relaxation of direct recruitment, appointment and placement under career advancement scheme it is humbly submitted that the relaxation of minimum qualifying marks by 5% for the purpose of appointment as per point 4 of the notification under AICT dated such and such. Also, career advancement scheme is a promotion to the faculty service subject to satisfying the requirement qualification and satisfying the eligible criteria. So they are saying that 5% is available. Only thing they are saying, disputed, Your Lordship, that this 5% when comes in the matter of promotion is not available. So what Your Lordship is ultimately called upon to decide whether it is available in every state.
Right, now we
and now my lord,
UGC.
Now my lord,
permitted.
UGC my lord, inadvertently it might have happened in my synopsis my lord, it do not come. I am concerned with AICT. I have pointed out to Your Lordship that notification dated 4/1/2016. Somehow it has been recorded my lord that 4/1/2016 issued by UGC. UGC never issued that, my lord. That is by AICT. That is on record of Your Lordship. Now 5%.
Now they have objected. You put a review application then.
My lord. Huh?
You
Lordship will page 2 of the synopsis. Lordship will kindly.
You withdraw this, Mr.
No, my lord. Then let the my lord. If that in that case Your Lordship can, my lord, let this matter may be decided by the because UGC also in the meantime AICT has filed an affidavit. Before the division bench, and the division bench,
yes, take down this business application.
Let it go and to be decided by the division bench.
Yes, this yes, we have division bench, but this application has been filed seeking correction of the judgment order dated 15/9/2025, passed WPC number 346/2024. Stop. The said correction sought by the petitioner appears in paragraph 2 and paragraph 6 of the judgment, wherein the word UGC with single inverted commas is sought to be corrected to AICTE. Stop. Mr. SN for the applicant submits that the correction is necessary in view of the fact that the relevant notification, that is which is one 4/1/2006 was issued by ACTE with regard to relaxation and not by UGC. Stop. This next paragraph, this contention or this application has been resisted by the state respondents who have submitted that the correction is not as simple as it is made out, in as much as the appearance of the word UGC in the judgment was on the basis of submissions made by the learned counsel petitioner itself, and further it would change the complexion of the matter. Stop. Next paragraph. As it is reported that the matter is pending consideration in the appeal, this matter is closed at this stage, leaving the parties to place this point for consideration before the division bench. This case stands disposed of this.
9.
Made clear. Lordship, this is the matter pertaining to the award which has been received, and then your Lordship has already decided in single bench, my lord, the award is challenged, saying that the award passed by the authority is a valid award and review of the award is not permissible. The petitioners went before the division bench, and division bench gave them liberty to challenge or pass independent order, my lord. In that light, they have come before your lordship.
Yes.
Therefore, the order.
Connected appeals are pending with the division bench.
You affidavit been filed by the state.
They are yet to file.
No, my lord, affidavit
in
has
this
not
matter.
been filed.
Then
that your lordship has already decided the issue. Sitting singly, my lord, we will file. We will place the judgment of.
I'm sitting singly now also.
Yes, my lord.
Squarely covered by earlier order. Squarely covered by the earlier order passed.
Which earlier order is this?
Those are Fredens in Thava.
Yes,
the batch of matters were.
Okay, then we dismiss it, Mr. Humphrey.
Lordship, the matter may be deferred for now.
Yes. As those submit, Mr. Kongsni, please.
Either your lordship will dismiss and let them file an appeal.
Subject to the-
Can be
subject to the outcome of
resolve the appeal.
Yes, Lordship.
Then we can't keep it pending unnecessarily. Then what to do?
Lordship.
These rested after 10 weeks.
Lordship, 4 weeks.
2 weeks.
4 weeks, Lordship.
4 weeks. Mr. Kongsni, the company plays the matter after 4 weeks to wait the outcome of connected
appeals.
Or connected
Writ appeal.
Writ appeal. Yes.
Writ appeal arising out of the earlier order.
The appeal arising out of earlier connected matters.
9 to 11.
It's 9 to 11.
9 to
9 to 11 are connected.
12.
Where's the additional affidavit?
Lordship, I seek some time to bring on record the undergone treatment.
See, if you're seeking additional compensation, you have to substantiate it. Yes. You are Mr. Upadhyay? No.
Lordship.
Yes. Praise for allowed further
2 weeks.
2 weeks time to file the affidavit allowed by the order dated 11/8/2026. Yeah.
13.
May it please your lordship, we are seeking further time allowed to file the affidavit.
Let him file, your lordship. Let him file, your lordship.
When does this file is matter? As paid for the 2 weeks time allowed for affidavit. Respondent.
Much obliged, my
This
lord.
regarding Tura matter?
Lordship, it is in William Nagar, your lordship.
Okay.
14.
Much obliged, my lord.
May it please your lordship. Lordship, I pray for...
Affidavit file.
No, your lordship. I pray for further 3 weeks time, your lordship, to file affidavits.
Promotion matter.
When's retiring?
No, my lords, they were granted promotion, but because of cadre review, they had withdrawn that promotion.
Withdrawn a promotion?
Lordships. They withdrawn the promotion order. They've cancelled basically.
Yes. Why no instructions received as yet?
No, your lordship.
Yes, as paid for the 3 weeks time allowed affidavit.
This is an interim order.
Interim order ready to continue. Has been stayed.
Lordships.
15.
Yes, pray for further 2 weeks time also to file the counter.
Yes. Pension matter?
Not pension matter. This is regarding service matter.
As paid for the 2 weeks time allowed affidavit.
Must.
16. 16.
Yes,
Please,
Mr.
your
Pasan here.
lordship.
Respondents are yet to file the affidavit, your lordship.
Fresh matter, your lordship.
Were reports given to him?
No, your lordship.
Last order. Where Dr. Muzika? He's left the building.
It's currently on legs, your lordship.
On legs where? Yes. You get instructions. Why is that? You only have to give the copy of the review medical board. Now it's already been found unfit, but you're not given the report.
The report
also.
if not received, your lordship.
Yes. What's your report? You'll give him the review medical board report within
2 weeks, your lordship.
within 2 weeks. Yes. MSC Jala today states for further 2 weeks time to file, 3 weeks time to file affidavit. However, it's noted that by order dated 11/8/2026, this court had observed that though the review medical board had been conducted over a year ago, the reports were committed to the petitioner to stop respondents to take counsel to take instructions for next this up to 2 weeks is by affidavit for instructions. They give the copy to him.
Yes, your lordship.
17.
Wait, please, your lordship. Your lordship, I'm praying for some time. We're awaiting instructions.
What's the matter? Any urgency?
Pension, no matter.
Yes.
Pension matter, my lord.
Wait further. Pension matter?
My lord.
You entering evidence today?
No, lordship.
How long you take for affidavit? For
We had to receive instruction, your lordship.
as paid for the 2 weeks time allowed to the respondents. Affidavit, yes.
Obliged, your lordship.
18.
Please, Your Lordship. This is a matter regarding the orders passed by the CM of Meliam concerning the pata and with the direction for demarcation of land and property at Laban. Your Lordship, along with this writ petition, I've filed one miss case appearing
now. Who's appearing?
I'm entering appearance on behalf of the Dorbashnang Matter, respondent number 5. Number 5. The Dorbashnang of Laban.
Lordship, I'm appearing for respondent number 6.
Number 6. 5 are you? You're 5.
I'm 5, my lord.
4?
For 1 entry.
1 second.
4 is the immediate
So, where's this village?
at Laban.
Oh, Laban.
Yes.
Now, 1 and 2 and 3 is Jareso. 1 appeared. 5 is Dorbashnang Laban.
Yes, my lord.
And 6 is
the private
Mumtada, right? Yes.
We'll
report first. Last time we were there, Mr. Jangreso, in the motion stage. It appeared. We had recorded that. Yes. Today, Mr. Ami Ahmed, Ms. Ami Ahmed has entered appearance. We have responded for 5. And your name?
S. Purkayastha.
And Mr. S. Purkayastha and counsel number 6. Stop. On behalf of number 4, the AD card is yet to be received. Stop. Submitted by Mr.
PV Kharmoshun.
PV Kharmoshun. Submitted. There's an application for what?
Lordship, there is a application. This is for seeking for stay of the impugned orders, Your Lordship.
For seeking stay impugned orders. You want to file objections?
Yes, my lord. I may be allowed to seek instruction.
Have it up to 1 week. As the
3
counsels
weeks
for 5 and 6. 3 weeks?
3 weeks.
Your Lordship, there is a matter of urgency because
2 weeks. 2 weeks, okay. As number 5 and 6, as counsels of 6 with the parents, this is a matter for 2 weeks for objections of a hearing under this application.
Hearing. Supplementary list item number 6.
Yes, Mr. Barasaji.
As far as the instructions from the department will not.
Then his name appears there. What instructions do you have?
The list which is enclosed, my lord, this list of the petitioner does not say that this is the list which is forwarded, my lord.
But you accepted that in the earlier case. How are we to have two? We'll have two opinions on the same list.
My lord, this the letter which is annexed, enclosed by the petitioner, my lord, which is at page 25. My lord, this is the OM concerning the ad hoc employees. Now it does not know where it mentions that this is concerning the
kindly see, my lord,
list of the petitioner, my lord. Here.
Kindly
only
see
thing I wanted to verify from the department, due to, my lord, only paucity of time.
See,
we have received one letter. This, my lord, there is one letter, but this printout is very the 11th August. I just wanted to verify whether his name is
page 9 of the rejoinder.
What happened last time was that on the basis of that list itself, we disposed of some matters.
Yes.
He is a non-teaching staff.
Non-teaching staff.
District council.
Yes.
So now he's come is similar. His name is then the same list with
same list.
But how can you have?
No, because earlier reputation, since I was not there in the earlier.
Who was there in the matter?
But in the earlier reputation, as per the
senior advocate T.M.T. and counsel Rossi was there.
Yes, but the order of the honorable court.
It is there because my name is then that document is not disputing. It is that belongs to their document only. It is issued by the none other than the commissioner secretary.
The order, where is it?
The order Lordship.
The order which was produced, copy which I received yesterday.
And then prior to this order also, they have referred another order.
So this order, last order. Bulima Mara was here.
Yes, this was.
This is the order which was referred yesterday. Bulina ke Mara.
And in this order also we have reflected earlier also we have filed that another writ petition where in the order dated we have mentioned that.
See, but you are more than 1 year short.
Yes.
Yes.
Everything. See, 5 years you have to serve.
Yes.
So for other people who were given just that they were 1 month, 2 months short.
Here in this writ petition, actually I was here in this particular case. I was appointed in the year of 1990. 1990.
That's for 94 years. Then
Yes, but others they appoint after 19.
Their
After
other
90.
consideration has not been given as yet.
Exactly, my lord. My lord, in para 11 we have clearly stated, my lord, because his as on June 1994, his length of service is around 3 years, 5 months, my lord, and 23 days.
4 years?
3 years, my lord, 3 years. 3 years, 5 months, and 23 days. So the length of service of the petitioner
We'll do that.
falls way short.
Mr. P.T. Sangma submits that the matter is substantially similar to WPC number 403 of 2025 and other connected writ petitions, wherein this court, by order dated 21/8/2026, had directed for consideration of the petitioner's case for registration, if permissible. Stop. Learned Counsel has referred to the list at the annexure.
Annexure 29, my lord. This is the same list. Actually,
Okay,
it is in my rejoinder.
That's referred to the list appended at the annexure.
Page 28, my lord.
At page
29 actually.
Page
29
26.
where my name is appeared.
In my copy it is 28, my lord. 29. This is of the rejoinder, my lord, not even the writ petition.
In the writ petition also it is there. The writ petition also my name is there. I have included.
Your name is?
Here in the
yes, is here.
7.
Referred to the list statement.
Yes. And this one is along with the
annexure 7.
Yes.
Where
actually this one
appears that number.
This
This
one
number can be seen here.
This is actually the along with the annexure 3 because there is only the annexure. See the cabinet memorandum is together with the annexure 3. Kindly see.
We'll go to your rejoinder affidavit.
Yes, Lordship.
Wherein the next at annexure. No, not 7. What annexure is this to it? Rejoinder?
Annexure 3. Then
to your rejoinder.
Yes.
Annexure 3 rejoinder.
That is a cabinet memorandum.
Where's your name? Chen Singh. Where is the petitioner's name?
Yes.
Under reservoir.
That in the list.
Reservoir para subdivision.
Yes.
Appears at table number 7. Top. He submits that as the same list had been relied upon by this court for passing the earlier orders, same consideration be given to the writ petitioner. Next paragraph. Mr. Q. Varachi Learned Counsel, Learned GA, has submitted that though it is not in dispute that the order would apply, however, what we should be kept in mind is that the writ petitioner has served for
only the qualifying service is
of
5 years. Is not.
How many years is 3 years?
3 years.
From 1991 is 3 years, more than 3 years.
3 years?
Yes, my lord, kindly. 3 years, my lord, it says 3 years, 5 months and 23 days.
3 years, 5 months
and 23 days.
Before the taking over by the state government of the services of the council school. Stop. Next paragraph. Whereas qualifying service is of 5 years.
5 years, yes.
As an earlier order been passed by this court, which effectively also addresses the grievance of the writ petitioner, this writ petition is also disposed of in terms of the order rendered in WPC 403, but in terms of judgment dated 21/8/2026 in WPC number 403 and the connected matters, especially para 10 thereof, which is reproduced here in video. Next paragraph, accordingly, matter stands as ordered above, the matter stands closed and disposed of.
Lordship.
We have recorded your objection. Let them consider. Is that a question of we can't direct for reservation also? Yes. Yes.
Most of the Lordship.
Daily list 36.
You think this matter is infructuous, Mr. General?
Not yet, Your Lordship. It's expiring in February 27, Your Lordship.
Last time that who had appeared under instructions, there had been some manipulation in this matter. That means
Yes, sir. Lordship has
because when
She was directed to-
such was directed by someone.
Lordship has taken the suo motu contempt.
Yes.
And suo motu contempt.
Yes, candidly
She's
admitted that. Yes, we accepted that because we can understand these junior
Yes.
officers. They will be under.
And she has very categorically stated some higher officers involved in the manipulations.
Yes.
That categorical statement that there has been a manipulation or higher officer involved has not been
just
there.
said that
It was not
I was
categorical.
directed.
She was directed by a high.
That's right. That is the case. And they haven't filed the reply also against the contempt.
Was not filed.
The
That's
officer.
okay. That's over.
Not filed the reply.
Yes, please. Okay.
There is also suo motu contempt. There is not the contempt filed by
So
me.
this we are in the main case now. Contempt will take separately.
Yes, yes. Lordship, the main case.
Contempt will take separately.
Yes.
Everything we do in accordance with law. That's all.
Yes,
we
yes.
can't allow any.
What is that? Lordship, the case is that I filed an application before this honorable court under 226 seeking the mandamus, directing the directors to give the approval. The simple my case was just direct them why they are setting over the matters, not disposing the matter, not giving approval, neither rejecting nor accepting. Then after hearing the parties, this honorable court passed an order. The impugned judgment, what you have given me? The judgment, page 200, judgment dated 5/3/2025. This is a judgment pass.
1 second.
200. This judgment. If you am allowed to read the judgment. The judgment, it says
what page?
Page 200, the running page, the judgment starts from 201. It says the brief facts of the case are that the term of the last managing committee of Rai Bahadur Hindi Secondary Schools stood expired on 3/2/2024 and the ongoing managing committee before the expiry of the terms had 31/10/2023 submitted a proposal before the respondent to for reconstitution and approval of the managing committee for a period of 3 years with effect from 4/2/2024 and 3/2/2026-27. However, in spite of expiry of the tenure, no approval was granted by the respondent number 2 for the said reconstitution, which prompted the petitioners approach this court by way of this writ petition, writ applications, praying for direction to issue the respondent number 2 to pass in necessary orders for approval. Mr. M.F. Qureshi, learned counsel for the petitioner, has submitted that though the proposal has been submitted well before the expiry of the term of the outgoing managing committee, wherein all the necessary particulars have been submitted by letter dated 31/10/2023, the respondent number 2 and 3, however, did not accord the approval on time. The learned counsel submits that everything had been observed as per the procedure, including the fact that the outgoing managing committee was a body which had made the proposal for reconstitution. He has further submitted that the reason given by the respondent on the affidavit that the proposal has not been cleared due to the fact that same had been objected by newly implemented respondent 4 would be of no consequences, as it was up to the respondent 2 and 3 to take a decision in the matters. The learned counsel then submits that there has been no managing committee for over a year, which had affected the management of the schools. Justice would be served if the instant repression is disposed of by directing the respondent number 2 to consider the matters on the basis of the proposal as submitted and take a decision. Mr. T. Angil, learned AAG, assisted by A. Nuwas, appearing for the number 1 and 3, has submitted that as the matter was yet to be decided by the competent authority, the respondent number 2 direction may be issued that the matter be examined and the orders pass in accordance with law. Mr. S. Jindal, learned counsel, appearing for the enforcement of 4, the association which has raised the rival claim of being a rightful sponsoring body, though not having any objection for the disposal of the writ petitions in terms of the submission of the learned counsel for the petitioners, and the learned AAG has however submitted the consideration and disposal of the matter by the respondent number 2 should be strictly in accordance with acts and rules as applicable. Having regard the learned counsel for the parties, having heard learned counsel for the parties, this court does.
Spectacles, Mr. Guruji.
Nowadays it doesn't work.
It doesn't, because I've noticed that in many, when you read now in few cases you're missing out lots of words.
Yes, because it's not working. The spectacle also.
How spectacles not work?
I know what happens. So all of a sudden it happens.
And you haven't got the eyes tested a long time.
I tested, but it's.
Yes.
Yes. Having heard the learned counsel for the parties, this court notes that the writ petitions had been filed on 30th/1/2024, as so approval had been forthcoming on the proposal for reconstitution of the managing committee of the school, whose term has expired on 3/2/2024. This court then, by order dated 1/2/2024, due to the impending expiry of the terms of the outgoing managing committee, directed the respondent 2/3 to take after the affairs of the school. To look after the affairs of the school in interim, a situation which is continuing till date. The incident matter has stood delayed due to the fact that the respondent 4, the Malwari Panchayat Committee, had sought the impleadment in this case, which was allowed by this court on 7/5/2024, and thereafter, after pleading has been exchanged and completed, a year has already passed with the issue still lying unresolved. As observed earlier, the petitioners' managing committee had come before this court only with regard to the non-grant of the approval of the reconstitution of managing committee. It is not a case where this petition has been filed impugning any order passed by the number 2. As can be seen from the affidavit of the state respondents, a decision yet to be taken. There was a counter claim and proposal put up by the respondent 4 to reconstitute the managing committee. As such, therefore, there being no legal point in the issue to be decided by this court, this court is disposed of by directing the respondent 2 to pass a necessary orders in the matter strictly in accordance with the law. It is expected the matter be disposed of. Then direction was given to the respondent 2 to dispose of the matters. Now, when the matters was not disposed of in time, and I filed a petition for contempt, that why the matter was not disposed of. Then they issued a letter. They issued a letter, page 212. This is the letter they have issued, that addressing to the Deputy Secretary to the Government of Meghalaya, and this is the proposal submitted by the Malwari Panchayat, appears to have been accepted. It says that in compliance with the Honorable Court judgment or order dated 5/3/2025, passed in WPC number 5, the Managing Committee of Rai Bahadur Hindi Secondary School, Kitty Road, Shillong, represented by its President, State of Meghalaya, and as per the direction from the Department's white letter number so and so, in continuation of our reply white letter so and so, I am to submit a proposal for reconstitution of the Managing Committee. This is Managing Committee reconstitution. So this has given me the fresh cause of action for filing the writ petition, and on the basis of this letters dated 13 August 2025, the contempt petition was closed, disposed of, since they had taken a decision. Now, in my writ petitions, the issue what I have prayed for, I made a prayer since having a new cause of action, challenging for quashing the impugned letter dated 13/8/2025 issued by the respondent number 2, the Director School Education Literacy, Shillong, Meghalaya, forwarding a proposal of the respondent number 5, Sri Marwari Panchayat, Shillong, to number 3, the Deputy Secretary to the Government of Meghalaya for approval of the Managing Committee of so-and-so. Then said further, the state are required to adhere to the related rules
So what
strictly.
happened after that?
Then what happened after that? There was a meeting. I attended the meeting also. In the government affidavit, they have enclosed. Then it starts page 17.
Number 2.
Page 17 of the affidavit in opposition filed by the state respondents.
Page?
Page 17. He said that the minutes of the meeting discussed the matter relating to the compliance of the Honorable High Court judgments and orders dated 5/3/2025 in WPC number 5 of 2025 in the office of the Director of School Education and Literacy, Meghalaya, Shillong. He said the meeting was chaired by the Director of School Education and Literacy, Meghalaya, Shillong was welcome all the members present. The proceedings of the meeting are as follows. The Director of School Education and Literacy briefed the judgment and order dated 5/3/2025 in WPC number 5 of 2025 and requested both the parties to make a submissions on the matters. The members representative from the Managing Committee, Rai Bahadur Hindi School, Kitting Road, Shillong, Kitting Road.
The schools were Limekra or in Kitting Road?
In the Kitting Road. In the Kitting Road. Informed the representation in that the representation has already been submitted to the Director of the School Education's member representative from the Marwari Panchayat Committee submitted an additional representations along with the necessary annexure in continuation to the already submitted representation made by them to the Director of School Education and Literacy made this. On hearing the submission made by both the parties, the Director of School Education instructed each party to provide a copy of their respective representation submission to one another. Additionally, they were directed to submit these documents to the District School Education Officers of Shillong to facilitate further examination of the issue at hand. Then the meeting will be scheduled for further deliberations on the issue. Date of the next meeting will be communicated to the parties. Then again, there was a meeting, page 18. It was held on 15 April 2025.
This meeting was held on
15 April 2025.
0503. What is this meeting on? On 23rd April.
Page 18.
No, page 17, 23rd April, right?
Page 17 is a issuing of notice only.
No, page 17, actually 3 is the minutes of the meeting.
Is also meeting.
Yes, no, okay, fine. Then
15 April 2015. Then here the party appeared, and then the director issued another letters. Is a page 20. In pursuance to the government notification, white letters so and so. The president of Managing Committee of Hindi School and Sri Marwari Panchayat so and so directed to appear before the undersigned on 29 April 2025. Then this is the meeting, page 21. Page 21.
Yes.
21. This is the meeting held on 29 April 2025. This meeting was chaired by the Director of School Education and Literacy, Meghalaya, who welcomed all the members present. The chairman requested both the parties to place and present their submissions, rebuttals with regard to the submission presentations made by the opposite party, taking into consideration the resolutions at serial number 4 of the meetings dated 15 April 2025. Member representative from Managing Committee submitted the following. The Marwari Panchayat relied on the judgment and order dated passed by the Honorable High Court in WPC number 341 of 2002. However, that order was set aside by the division bench in writ appeal, which was concealed by the Marwari Panchayat. Reference was also made in the case of Madrasa school regarding the sponsoring body. School is not a minority school. The directorate has got limited role and lack consideration to decide the right, title and interest of the Marwari Panchayat committee, that it can be decided only by the court. Role of the director is only to examine the proposal forwarded by the outgoing managing committee. The Marwari Panchayat has no locus standi and no weight of audience. Member representation from the Marwari Panchayat submitted that the following acknowledgement: receipt of the representation dated 11/4/2025, a rebuttal representation of which the chairman acknowledgement is taken on record. As per rule, the secretary of the managing committee who should forward the list of the new proposed managing committee. However, the list was forwarded by the president. That was their objection only. Only the names of 9 members to be submitted by the outgoing managing committee, whereas the name of the other remaining members are to be added. The school is not a minority school. The Honorable Court stated that the Marwari Panchayat was a sponsoring body, as Marwari Panchayat is the sponsoring body, and also the school was established by the Marwari Panchayat itself. The the district school education officers submit the following submissions. As per the prescribed criteria, it is the outgoing managing committee that should submit the proposal to the managing committee, acknowledge the receipt of the proposal from the Marwari Panchayat committee, which was communicated to the directorate. The proposal was submitted by the president of the outgoing managing committee, and authorization was given by the secretary. Authorization was given by the secretary to the president to sign the proposal. On hearing the submission made by all the parties concerned, the chairman stated that all the previous writ petitions have been put on records for perusal of the matter for passing necessary orders. That issuance of the order by this office will be made soon, and the same shall be communicated to both the parties. Then this is the type copy. Then on to a meeting, in the meeting of 29, page 24 shows that even I also appeared. I represented the serial number 12, and from the Marwari Panchayat also they have also appeared. MP Singhania, these people appeared. Now, after hearing both the parties, the director was the one who was directed by this honorable court to decide the matter in accordance with the law. Now, the director has passed an order, very speaking order he passed, page 28 of the affidavit in oppositions. Because it has to be confined only that the committee has to be approved in accordance with the law. Outgoing secretary, outgoing managing committee has got the power to submit the proposals, and it is forwarded by the district school education officers to the directors seeking approval, and director has decided this. Director said, page 28, in compliance to the Honorable High Court judgment order dated 5/3/2025, passed in WPC number 5.
Annexure 7.
This is the annexure. Annexure 7. The decision, page 27. The managing committee of Rai Bahadur Secondary School, represented by the president versus State of Meghalaya, I am to state that the proposal for reconstitution of managing committee of RBA Hindi Secondary School for a period with effect from the date of issue of this letter till 3/2/2027, in reference to the letter dated 20th November 2023, forwarded by the district school education officers, East Khasi Hill, Shillong, is hereby approved. So these are the committee approved, forwarded by the managing committee. Presidents, the name of the given of the office bearers, members. Now further, in the interest of schools and in accordance with Rule 2E.
Dated when?
Date.
Dated of, what was the date of this
First page.
order?
Date no mention. 26. Then again he said, if the director is deciding in accordance with the law, further in the best interest of the school in accordance with Rule 2E of the Section 11 of the Assam Education Department rules.
No. Where are you reading from?
No, this is the office
order.
After office bearer.
No, the date of this order.
There's an order. If he starts from the Annexure 7, then it is order
26 May.
26 May, yes.
It comes sequential, right?
Consequential, yes. Then the finding of the response number 2, the director of school mass education, that further in the last, in the interest of the school, in accordance with Rule 2C.
Interest of the school, in accordance with Rule 2.
Yes.
Yes. Yes.
The 2 persons from their committee also was taken as additional members in the committee, and saying that there can be co-opted members shall enjoy all the rights, and this should not be taken as a precedence. So this is the order passed by the director in pursuance to the order of this Honorable Court, because the Honorable Court did not direct any of the officers or the higher authority to decide the matter. The decision is to be taken by the director with a speaking order, because the matter was heard by both the parties heard. We have filed our written arguments and the matter was heard. Even I also took part in the hearing. Now the problem start coming from the government. The government started interfering in this order. The government issued a letter 1st July. He said, in inviting reference to the letter subject, I am directed to inform the draft orders, not a speaking order. They cannot examine this order. Whether it's a speaking order, not a speaking order, the order has to be examined by this Honorable Court only.
It's already been issued.
Yes, not been issued, not a speaking.
Order is already issued.
Not issued.
This 26/5 already issued.
Yes. Which is a format request you to kindly furnish all the relevant documents of managing committee in respect of the school for further necessary action. Now, second letter they say.
The same person is author of this order date 26/5, correct?
Correct,
Letter
yes.
and order. Right. Now he writes Annexure 7 reference of the draft approval. It's a draft, okay.
Draft he said. Then again, page 30, Annexure 9, he said, with reference to your letter, subject cited above, I am to forward all the relevant documents, managing committee in respect to Rai Bahadur. Then, in response to the letter, Annexure 8, he submitted all the letters. Now, the secretary, he passed an order, page 31, Annexure 10. He said, in inviting reference to the letter subject cited above, I am directed to state as follows. The owner of the land and the owner of the school building has every right to constitute the school managing committee as per law. In case the owner of the land and the building seems to be Sri Marwari Panchayat, therefore the Sri Marwari Panchayat has got the right to form a managing committee if there were any objection claim against the ownership of the land. If anyone else to be a sponsoring body that need to be considered by the DSEL, by hearing all the claimants parties. This is the order passed. Thereafter there was no hearing at all, and finally this order is passed. The order passed approving the committee which is under challenge. This is the order passed without hearing the parties, without asking the parties to file their to be heard on this issue,
and
without any findings.
From this managing committee?
Yes, I am ousted from the committee.
And you are the outgoing managing committee?
I am the outgoing managing committee. So as per the rule, I am also the outgoing managing committee is entitled. So how they are going to justify this attached with no findings? Simply a letters, contrary to the findings of the directors of school education who given a very clear findings, and stating that in the interest of the schools then...
The final order?
There was the final order passed after hearing the parties. And
so who's running the school now?
The school is being run by the district school education officers. So there is no justification of this order. So suddenly pass an order in favor of Marwari Panchayat without any findings.
But you have not made a subsequent challenge to this?
This is the order under challenge.
In the writ petition?
In the writ petition, yes.
This order did, oh yes, 13 August.
This is under challenge.
Yes. Yes.
So my humble submission is, Lordship, that the order passed by the director earlier, page 28, is a speaking order passed after hearing both the parties. There's a draft order, but there's a speaking order. So it means the director has to pass.
26 May.
26 May.
Yes.
Director has to. It is the director has to pass the order. And even if the order, if any of the parties agree by this order, they can come to the court by way of judicial review, whether the order is right or wrong. But the director cannot, the secretary cannot act as the appellate authority, reviewing the orders or telling that, or giving direction them not to do this, not to do that. They are not, have no authority, because it is between the court and the director. Court has given direction to the director. Now they are answerable and accountable to the court. They have to reply to the court that what they have done pursuant to the judgment order passed by this court, directed them specifically that they have to pass in a speaking order after hearing the parties, and they have heard both the parties were heard, and the order passed by this one, it appears that this is the order passed by the directors. But subsequently passing an orders behind from the back, not informing us, not communicating us also that such committee is going to be constituted.
Yes.
So this is a writ petitions. These orders is not sustainable in the eye of law. How can they justify the orders?
Yes. Yes, have they filed affidavits, all of them?
They have filed affidavits.
The other, yes.
Once more, look on your Lordship's order at page 200 of the writ petition. And the relevant part of your Lordship's order is, my Lord, on which my friend has placed reliance.
Yes.
Paragraph 8 at 204, my Lord. Order starts from, my Lord, 200. Relevant paragraph is paragraph 8, my Lord, at 204. As such, therefore, being no real point in issue to be decided by this court, the writ petition is disposed of by directing respondent number 2 to pass necessary orders in matters strictly in accordance with law. So, your Lordship has directed respondent number 2 to pass the order in accordance with law, my Lord. That is the order passed by your Lordship, that we have to follow the law. That is, and our case is that we have not violated the law. Your Lordship will have the law at page 20 of the writ petition.
20.
Page 20. Law is placed before your Lordship. Because, my Lord, the law which pertains to appointment of management committee is part of, my Lord, Assam Education Departmental Rules and Order, which has been adopted by Government of Meghalaya, my Lord, read with Meghalaya Education Act. These are the two acts which are relevant, my Lord. Now, your Lordship will have the rule 1 first at page 20, my Lord. Every government-aided high and middle school shall be governed by representative managing committee, the constitution of which has been approved by the inspector or inspector of schools, as the case may be, save in cases where the director allows an exception under circumstances. So, Lordship has seen that aided colleges will be inspector of schools, as the case may be. That is the requirement, my Lord. Now, rule 2, my Lord, composition of the sources of appointment is there, my Lord. Save in cases where director sanction a special committee under circumstances, each managing committee shall consist of one president, one secretary, both of whom shall be nominated by government. Your Lordship, kindly mark that the secretary and president will be nominated by government, not by the management committee. And 10 ordinary members, except in case of middle school, where the number will be 9, which shall include the headmaster. 2 members except in case of middle school, where this number will be 1, to be elected by teaching staff. So 2 members will be elected by teaching staff, my Lord. 2 members to be elected by guardian, and 1 member elected by donor of not less than 500 rupees subscriber annually, and 4 members to be nominated by government. So power of nomination is given in the aided school under the rule 1, my Lord, to the government, my Lord. And 2 has to be elected. It is not the managing committee which will decide, my Lord. Now, my lord, kindly see the proviso is very clear, that the rule is very clear. Four have to be nominated by the government, and the order also says, my lord, the shall be consist of president, secretary, both of whom shall be nominated by government. So power of nomination, power is vested with, and only 5 of them will be elected by the school, my lord.
So see, in the earlier recommendation, 2 of them were nominated by government. That what the school from the Marwari Yuva Manch. Oh,
I'll take your lordship to the facts, my lord. Let me take.
What is the difference between Marwari Yuva Manch and Marwari Panchayat?
No, I'll take your lordship to the facts.
Yuva's youth. That is.
I'll take your lordship to the facts, my lord. I'll take first. What I wanted to place before your lordship is that the rule requires nomination by government. Rule requires nomination of the person by the president, by nomination by government or president and secretary, my lord. Now, rule 11.5, my lord. Kindly see 11.5.
11.5.
11.5, my lord. Page 21, my lord.
11.5.
Yes, my lord. These are all part of rule section 11 only. Section 11, page 21, 5, my lord.
Yes, okay.
Yeah. Yes. Subject to rule 4 above, the terms of managing committee was ordinarily expired 3 years from the date of first sitting of the committee with required quorum on being reconstituted, but the member will be eligible for reappointment or re-election as the case may be. Not later than 3 months before expiry of term, secretary of the committee shall intimate to the inspector of school the actual date on which term of existing committee expires and shall forward along with the names of newly elected members to the election being held well ahead of time. If the members of elected members are not received, managing committee shall be reconstituted by inspector of schools with the nominated members and headmaster without reference from the school authority. So, my lord, what is required under rule section 11.5, though it is called section, but it is a rule, is that before 3 months, the secretary will intimate to the inspector of schools the elected members, my lord. And if elected members are not informed, my lord, then in that case, the committee, there is no requirement to consult previous management committee, my lord. That is the law which is governing the field, my lord. Now, my lord, the act, my lord, only one provision of the act is that Meghalaya Education Act says that competent authority, director is different, government is different, my lord. These are the 2 different authorities. Director is not government, and power, your lordship has seen that first rule, your lordship has seen 2 rules very clearly, which exclusively gives the power to the government. Headmaster will be ex officio, free elected constituencies, and government nominations, my lord. This is the requirement. The rule also says, my lord, the rule 5 clearly says that through secretary, it intimates the date of expiry, forward the names of newly elected members. This is the power vested in the previous outgoing committee. It nowhere empowers, my lord, the management committee to propose a president, secretary, or nominated.
Just come again to the, where's that request that, where's that?
I'm just going, I'm taking your lordship to that. Your lordship, I'm now, law is very clear, I'm taking, your lordship will kindly have 3, their annexer.
1 second.
Page
long,
55.
This is got a long checkered history. 1 second.
Yeah, page 55.
1 second, was that General. 1 second. Be patient, please. We're looking at something else. We'll come back later. Yes, continue.
Yes, my lord, I'm sorry, my lord. So, my lord, if your lordship will see, the the earlier committee, etc. Kindly have my counter affidavit, my lord, because in counter affidavit all documents are placed, my lord.
Yes.
And I'll take your lordship to the page 1, my lord. If your lordship will see first their proposal, my lord, because what they are saying that I have proposed. Sorry, my lord, kindly come back to the writ petition again. That is page 55, my lord.
Yes.
And your lordship will see this is a letter of district school education officer of November 2023, my lord, 30th November. And it says, my lord, reference to letters from the referenced from letter number 31st/10/2023 with reference to the subject cited above. I am to forward here with the proposal of reconstitution of managing committee with members as indicated below for 3 years with effect from 4/2/2024 to 3/2/2027 as submitted by President, Managing Committee and Shillong. Now he himself, my lord, says that I will be president. It is his proposal before Bimal Kumar Bajaj. Secretary, he says I will. Secretary, he decides that I will be secretary, joint secretary, guardians representative, donors representative, and nominated member. This is a proposal, my lord, and you will also will find that proposal given by the management committee, nominating himself as president, nominating himself as secretary, and and this is a proposal which was given by my lord, none other than by President, my lord, not by the secretary, by the petitioner.
Petitioner is the president here on this list.
He himself, yes. President is president, my lord, himself is president. Now he says that I should be the president under the proposal, my lord. With the greatest respect, my lord, he cannot nominate himself. That power under the law is not vested in him. That power is not vested in him, and if he is exercising the power, he is exercising with material irregularity, my lord. That is my first submission. Under the rules, he has no right to nominate himself. Now kindly have then the matter travelled before your lordship. The lordship passed the order, the order was passed, my lord, and then in terms of the order, then your lordship will kindly have the counter affidavit, my lord.
Yes.
That, my lord, will find Annexure 3. Good one. Sequence of the event, my lord, at page 17.
Page 17.
Yes, my lord.
Yes.
This is this your lordship will find that on pursuant to a notice was issued, my lord, parties, director of a school convened them. All sides were, my lord, were convened. Director of a school hearing was there.
No, yes, one query only is that, look, yes, this is all water under the bridge, okay? Yes, now, fine, now this, that proposal was made and there was already a draft reconstituted magic
given by director.
Exactly.
By director.
So what happened to that? What are circumstances that you know that you know that made the change necessary? That's the only thing. That's what impugning. That's all. They're quite happy with whatever was reconstituted as per the earlier. That is on 26 May. 26 May, they're quite happy, but the whole thing changed after 13. That's the only thing, because now all these submissions you're making are redundant. The sense that they all, that water under the bridge, whatever happens, happened. Rules, divorce the rules, apply the rules, forget about that. Now the only thing they agreed about is that fine, if it was taken into active, I mean, consideration by the respondents, and this was come up with. Now why is there this turnaround? What you know? Dedicated that, yes. That's the only thing you have to answer. Instead of going to the rules, going to the earlier, forget about that. Yes.
Yes,
The only thing, now whether on the face of the record, there is some irregularity or illegality, that's all. In the reconstitution that was done after 13/8 compared to 26 May, that's all. That's the only thing. Now the only thing is that what were the considerations that was there before the DSEO when he reconstituted in 26 May, and what were the considerations that he took, on board or whatever into later on to arrive at a totally diametrically like different management. That's all. We're here to do justice, that's all. And if we find that is due to some extraneous consideration, I think we will set it aside. That's all. Simple as that.
Yes.
Yes. Not we don't care about considering any personal interest of anybody here. That's all.
Yes,
just going as per law.
That is not. That is not.
Simple to the whole thing. What you submitted. That is. It's. I mean. I may be wrong, but I think that is yes. We come to the core issue. Yes.
I know, Milord. There are two parts of it. My submission have two parts, Milord. One part, Milord, is that Lordship, the management has to be constituted in accordance with the rules which are in place, Milord.
Of course.
That is the first core.
That's non-negotiable.
And not negotiable because that is a foundation, Milord, of his right also. His right also. His right will flow from that right only.
Yes.
Now, what your Lordship will have, the proposal, whatever proposal he has given, those proposals cannot be given. Now, kindly have the page 27. Your Lordship pointed out that there is a U-turn in the approach of the government. Milord, kindly have the aspect at page 27, Milord.
Of the affidavit.
Of my affidavit, because this is 26. Milord.
Right. Okay. Yes. Let's start from there. Yes.
Yes, Milord. Because I have to place the law, Milord. Then thereafter, I will take your Lordship to the draft order and draft rules.
Of course. Yes.
Now, Milord, page 27. With reference to the cited above, I am to forward here with a draft for approval in connection with the reconstitution of Managing Committee of Rai Bahadur Hindi Shillong in favor of your an action in the matter. Now, Milord, if this is the draft order, this is the draft order which was sent to the government.
Yes.
Director has sent the draft order to the government. Now, under the law, your Lordship has seen, this is a draft order in which what is their case, my Lord? Prayer also, your Lordship. In the writ petition, your Lordship will have to have a look of prayer also, after I so. Prayer is to set, if your Lordship will see the prayer, what is the prayer? So that the prayer is at page 16 side by side.
Yes.
Was the impugned letter of 13th August 2025, my Lord. That is the prayer which they now kindly have the draft order, my Lord. Again.
Yes.
The draft order your Lordship has seen, page 27. Now, their whole case is based on that I am, in terms of draft order, whatever order has been forwarded by director is final.
No, not that. No, we're not concerned about that. We're not concerned about their case. We're concerned with 1st July. Now it says inviting a reference to the letter. I am directed to the draft, not in the speaking order format. That's the thing.
Yes,
and the question furnish all relevant documents. Now, what documents were furnished? That is what documents were furnished to affect the turnaround from the draft proposal. That's all. That's the only thing.
Yes, my Lord. Now, so, my Lord, the issue which calls for Lordship's consideration is that this draft order carries no sanctity in the eyes of law. It is a draft order. Because it's a draft which is put up to the government. Government is the final authority, my Lord. Now, my Lord, then the department these are all internal communication which is taking place between government and directorate. Now, based on this, it says that you pass the not format and request format means what if your Lordship will kindly have page 29.
Now, okay, fine. Now you come to page 31. That is what I can't reconcile. Cannot reconcile. Is going to reconcile within the speaking order. See, speaking that now he said, okay, fine. If the draft order is not speaking order format, give the justification. Now, when you come to 31, in all fairness, Mr. Archival General, now you see what's written here. So
yes, I'm placing. Kindly give me one moment, my Lord. I'll placing all these 3-4 pages, my Lord. These are the pages which will turn the case one way or the other.
Yes, of course. Now, yes, that's the only thing. That's the only thing we want.
Just give me 5 minutes, my Lord. 5 minutes, my Lord. Then thereafter, 29, your Lordship will see. 29 says, I am directed to inform that draft order is not in speaking order format and request you to kindly find relevant document related to reconstitution of in respect
Yes,
of
accepted.
So the requirement is, my lord, the requirement is that president and secretary and nominated members will be
Yes, fine.
nominated by
Accepted.
government.
That is per law.
So then director nominating, my lord, director nominating, because director has given a proposal that I am proposing so and so, because director has forwarded the proposal of management committee. Director is saying, director is nominating. So then, my lord, if your lordship will come up to page 31, my lord.
That's the how this is the letter that's very that has drawn attention to the court. That's the only thing. That's attracted attention to the court. Yes.
31,
yes.
31. Inviting reference to my letter is saying so the owner of the land and owner of the school building has every right to constitute school management committee as per law.
Yes.
Kindly have this line, my lord. In case the owner of land and building seems to be Sri Marwari Panchayat has every right to form SMC as per law. If there is any objection and claims against the ownership of the land, building, if anyone else claims to be sponsor of the school, needs to reconsider DSEL by hearing all claims. Panchayat, after hearing the minor right above, you are advised to submit the proposal. This is again written by my government to this deputy director of the school, my lord. This is a letter of 29 July written by saying that please examine this factor also in constitution of management committee. In constitution.
One thing, where is this question of ownership come now? That is what this court can reconcile what is going as per law. Now the powers with you to nominate and then okay fine call for election of members. Now call election members. Now suddenly this letter comes up from nowhere. Where this thing is a speaking order. 29 says up to 29 with appraisal everything perfectly all right. Up to 29 everything is all right. Up to 29, but from 31 then you will hear it later.
Yes. Now your lordship's query is that why there is a change. Director has proposed nominated the members. Director has nominated the members. Director has nominated the president. Director has nominated the secretary. That power is not vested in director, my lord. Under the law, your lordship has seen. And if your lordship will see the nomination, my lord, then director has taken into consideration, my lord, and page 32, your lordship will have 32, my lord. 32, director has taken into and has proposed, my lord. Ultimately, it is for the government. What they say that they have right to become president, my lord, or by virtue of recommendation given by director in draft letters, my lord. It is the government has asked them to consider this factor that if there is a ownership, why he should not be president of the society. If there is some ownership of secretary, why should he not be? Why not? So these are the discretions which are vested with government, my lord. Under that who will be president, who will be secretary, and their right is confined to the elected members, my lord. If your lordship will see the page 32, my lord. President, this is the deputy secretary, the in compliance of order so and so. I submit the proposal of reconstitution management committee as proposed in sponsoring body. The names of proposed office bearer are this so and so and so. And kindly, my lord, kindly have the nominated members. Then teachers representative, guardian and donors. 5 are so they have, my lord. So far as this all are concerned, my lord, nominated president, etc. They are all vested with the government, and ultimately government, my lord, at page 34. This. My lord, or your lordship will this 34 government, my lord, if your lordship will see directors have nominated how many, my lord, kindly see the 13th August letter, my lord, page 31 for a moment, my lord. President Ramesh Bauri, secretary Mahavir Prasad Singhania, joint secretary, headmaster ex officio, nominated members Santosh Chauhan, Pawan Sharma, Sri Rahul Bajaj, Vikram Singhania, teachers representative 2 members, guardian representative 2 members, donor representative 1, my lord. Now kindly have the government order, my lord, at 25th August 2025, my lord.
Yes.
My lord, see, my lord, the president, secretary, lordship will sign, and then, my lord, your lordship will have the joint secretary, nominated members, my lord. The government, so government has right to nominate, my lord. Government cannot touch teachers representative, guardian representative, donor representative. The whole case of the petitioner before your lordship, in my humble submission, is that once the director has nominated, he is the final authority, which is against the law, my lord, rules again. and government is saying that you can take into consideration these factors, my lord. Now kindly have one aspect in mind also, my lord. The writ petition, my lord, has been filed. If your lordship will see, writ petition has been filed on the date of filing of writ petition, my lord, is, my lord, 18/8, my lord. 18/8, my lord, is the date of filing of the writ petition, my lord. The order, if lordship has seen, as 34, my lord. 34. That
It's
order
25th.
is at, yes, my lordship, at 25th August.
Yes.
Now, 25th August order is not challenged. This
No,
there is no
that will
challenge.
take, we can mold the
Yes,
release.
but if you are not, my lord, if you are not, and why have you not challenged? Why have you suppressed this letter when you were having this letter with you in contempt petition, my lord? If your lordship will see.
Yours, to your knowledge, 25th August.
None of the letter was communicated to us, except in the contempt petition they produced only one letter.
Anyway, yes,
it, my lord.
heard petitioner Advocate General.
I will
Hearing
have some
next week, yes.
Yes.
You still, you see, one thing you have to address is 31, by the letter 31 itself, it allowed all parties to produce whatever materials they have before the DSEL, correct, for consideration. Now that has to be seen. We will see also, we'll call for the records. Whether what money is produced. We are not happy, we are not happy.
Two lines, my lord. Your
Yes,
lordship
next week, yes. Next week. We have other matters also, Mr. Peter.
Lordship, this is no question of nomination. The exact proposal submitted by the Marwari Panchayat was accepted.
We'll have you next week, Mr.
Yes,
21.
We have some other considered matters.
Second or third?
Whatever date you're not third.
Second?
Not third. Huh?
Second?
Second's fine.
Second. I'll leave this.
Thank you. Yes. This 21 who's appeal 21.
In this, we have settled this matter in
This is settled before the Supreme Court.
Yes, my lord, but we are yet to receive the order. It's not been uploaded as yet. Kindly just defer this matter, my lords, for just 2 weeks.
It is reported the main matter has since been disposed of before the Honorable Supreme Court. Only this is a matter after
2 weeks, my lord.
2 weeks, yes.
Leave.
Yes. You see, Mr. Advocate, I don't want to prolong the hearing, it'll take the whole day. Because Mr. Jindal will have come on, it would have never concluded. So that's why if other matters and have other. Yes.
22.
Yes.
May it please your lordship. Lordship,
ready?
Yes, lordship.
Yes?
Dr. Mozika is on his way.
He's on his way or on his legs?
He's on his way, your lordship.
Lordship, I have prepared some points pertaining to this case for ready reference of the
You've prepared some point, but you signed your own payment order. Then how are you asking now?
Lordship, I will satisfy that.
You impugned the own order you signed.
Lordship, what happened here? First of all, they have not raised this objection in their counter affidavit.
No,
Lordship, I'm coming. That also I'm coming, Lordship.
Now you're challenging an order whereby you said I should be paid this much.
Lordship.
Correct.
Lordship, that is
first case where you're impugning an order signed by yourself.
True, Lordship. Lordship, but it is a settled law that the principle of estoppel do not operate against a statute or law. It is settled law. So even if I do mistake, if the law is there, then I am entitled, Lordship. So, Lordship, for this I rely on some decisions of this Honorable Court and the decision of the Honorable Supreme Court.
Where Dr. Mozika? He's ready with the matter today. So you see, that's the only point.
Lordship.
Now the order is signed by you.
Lordship. Firstly, Lordship, they have not objected this point in the counter affidavit. Now they are coming with this objection that I have signed. So even I am accepting.
No, do you deny that you signed it?
Lordship.
You don't deny.
No, I am not denying. Yeah. But Lordship, that was my bona fide mistake. So they cannot take advantage because of my bona fide mistake. And Lordship, and law is also settled that principle of estoppel does not operate against law, Lordship, against statutes. And the judgment and order dated 17/12/2012 has clearly mandates that I am entitled for that pay scale, Lordship. It's clearly made.
So was they ready to matter today?
Some other day. We're supposed to give
the points. You let me see the points. Very interesting case. But you're not taking that in your counter that he signed. He's the one who signed the order himself.
No, Lordship. There is
And it's
no
impugned
objection.
himself. Yes.
He signed himself, my lord.
Yes,
Yes, he
I'm
signed himself. Do not
admitting. I'm
deny it.
admitting. These are the points, Lordship, points with regard to this case.
Let's give him a copy.
Yes.
This copy.
You give a copy. Yes.
Yes.
On the period, Mr. B. Deb has supplied. What is this called?
Lordship, these are the
Just update. Points.
points pertaining to this. What is the issue in this case,
Some
Lordship?
points.
What is the issues in this case?
Yes, sir. A copy is made over to the GSEI. This is the matter after 1 week.
Lordship.
You come prepared.
Lordship. No,
What
sir,
authorities?
prepared.
Have you given the authorities also?
Lordship, I have
Kindly give the citations.
I have
will
now
examine
also
it.
I have, Lordship.
You just kindly give the citations to the.
Yes, Lordship.
We'll
I'm just
examine it.
yes, Lordship. I'm just.
I know. So you mean to say when you signed the order, you didn't look at what was there in the order?
Lordship, it was my bona fide mistake. I'm accepting that was my bona fide mistake.
Yes. After 1 week. Yes.
Lordship.
25.
Yes, Your Lordship.
Very with the matter.
Earlier, my colleague had seek for adjournment, Your Lordship.
Yes.
Earlier, my colleague had said seek for adjournment, Your Lordship.
What happened?
The
The
morning,
objection from the
but
She had objection. No?
yes,
After 2 weeks. Yes.
Much
on the Mr. SPM.
26.
Appeal. Yes, Mr. Walang.
May it please your lordship, before I give my submission, this matter is been placed before mediation on 3 occasions, but unfortunately the matter could not be sorted out. Because of that, there's no other option. You have to come back for this court. The main contention here, your lordship, at the time when they laid the pipelines in my land, they have never got the consent or the information, the knowledge from my side. Despite of that, we have given the representations, series of representations, your lordship, but they did not pay heed to that. The respondents. Hence, there's no option.
Now, did they build a structure or only did they build anything on your land?
The pipelines, a
No,
very
you
big
mean
one.
The pipelines.
It's a very big.
No.
Yes.
See, if you're asking for benefit of that memorandum, whatever, that means they have to be an installation in your
Yes.
land. Installation means a pump house or
Yes, a pump, yes.
building where then a member of your family is given appointment, right?
Yes.
Now you see only pipes.
Not only pipe. I'll just give you to. Let me just.
Attach any photographs.
Yes, your lordship.
Where are those?
Page 52, your lordship.
Now, produce is a map.
Yes, your lordship. Moreover, your lordship, even my land now has been totally become useless, your lordship.
What do they say in the affidavit?
In the affidavit also, they've already admitted, your lordship, that this is my land. In fact, in the counter affidavit,
You're praying for representation to appoint the daughter of the petitioner.
Yes, your lordship. That is my thing.
Then they can compensate you for the land destroyed. What about about appointment?
No, let me.
What do you say, Mr. Abraham?
Your lordship, with your permission, your lordship, with your permission. In the counter affidavit also, like I've mentioned, in page 4 of the counter affidavit.
Yes. Yes.
what is mentioned in the last para, Your Lordship. With your permission, can I read?
Please, please.
Yes. It is seen from the above, serial number so and so, the total length of pumping main pipes. This is 350 millimeter diameter in so and so meters, whereas the length of pumping main which passes through the land of the petitioner is hardly so and so. Hardly, they said, he mentioned, Your Lordship.
110 meters.
Yeah, which is only so and so of the total length of the pumping main land, and occupies, now they've already admitted, occupies an area of 385 square meter, which is, Your Lordship.
What I'm saying, Mr. Walang, is not regarding the factum of the pipeline.
Yes, yes.
The fact of what relief you're looking for. Appointment, I don't think will be possible. You can seek for compensation for the damage and for the land, the 385 meters that is gone for a land. That's all.
See, my compensation, Your Lordship.
Suppose he donates
my
land, and suppose, see, to get the benefit of this government
I understand.
memorandum, PHE has a scheme of, I think,
so many.
You have to be a donor. Okay, Mr. S. Walang, donate this land for the purpose of setting up this pump house, whatever.
I understand.
Then an agreement itself is given that, okay, in lieu of, so Mr. S. Walang's family relative who will give an appointment. Now, this is not your case here. Your case here is that now, okay, fine, they've taken a part of your land, or part of the land has been spoiled. But then it's not a case of you giving voluntary donating that portion of the land to the respondents, and in lieu of that, giving you something. Now he has destroyed. They should give you. They should compensate you.
No, I understand, Your Lordship. But
then you're asking for appointment. So
compensation by way of compensation.
How will they give you
compensation by way appointment, Your Lordship, which I will specifically mention, Your Lordship.
That can't be enough for whole lifetime. Your daughter will work. That's compensation.
No, because actually donation can always be done, Your Lordship, if provided, if I know about that.
No, you take instruction
without knowing.
You have to change your prayer. How will they appoint you? That prayer, we can't direct, and we ask for direction to appoint a daughter of the petition and PG department.
Because I would sincerely donate the land. But that also they've done it beyond my back, Your Lordship. So I have to say they deprive.
Who gives the NOC for that?
That is very important.
Who gives NOC?
Now we'll come to that. Yes. That's what we mentioned in the counter affidavit, Your Lordship.
Who gave NOC
to Your Lordship
for having the pipeline through your land?
This is the minutes of the counter affidavit, Your Lordship.
Yes.
Page 14. Members.
Were you present there?
I was not there, Your Lordship.
Where's number 14?
Yes, Your Lordship. In the counter affidavit.
Yes. Page 14. Members present meeting in the same long time.
Oh, sorry, Your Lord. Sorry. By mistake, page 12.
Page 12.
By mistake.
Yes.
Yes.
Who gave NOC?
Resolution so and so and so. Who are the members? I mean, specifically mentioned in para 3. Chairman so and so, vice chairman, members, and so on and so forth. Now, I'd like to draw your attention, page 13, Your Lordship. That's very important.
Yes.
Yes, para 5. It has been decided, that means in the minutes, in the meeting held, which has also been reflected in the minutes. It has also been decided that all village elders are to obtain NOCs, Your Lord.
Yes.
From all the land allocations. What does it mean? I mean, to my limited knowledge, it should get the NOC from me first, being the owner of the land.
Did you make complaint with your Darbarshnang?
Yes, already.
The complaint's been made.
No, we have not accepted the representation we have given to the.
No, to the government, to the
village elders.
Your village, have you?
Yes, unfortunately, we have not. We have not done
complaint.
That. We have not done that.
Why? Have you made them party here?
We have not.
Then no one can be deprived of their property without the presence of law.
Yes, yes.
And in your case, what has happened? If you have a genuine grievance, your land's been taken over, a pipeline running through your land, 110 meters, whatever. the amount of land that's been spoiled runs to 25 square meters.
Yeah, 4,000
That's
square feet.
consent. We understand. I think you have to complete your. Otherwise, what directions can we pass?
So if need be,
Yes, Mr. Abraham.
we'll amend the.
You examine it, but otherwise you have a general grievance. Only that has not been angled in the proper manner.
Yes, Your Lordship.
Only thing.
Only that portion is not.
We're not in an advisory capacity,
No,
but you just examine.
It's understood.
Sit with the file
We'll amend in the.
carefully and just see yes. At the
Just
request of
to
Mr.
just implement the.
yes, along list the matter for 2 weeks. Otherwise, you can withdraw and file afresh also, if you wish. Then you can put them as respondents. Then the whole prayer you can change.
No, I understand. Yes.
You take it, I guess.
27.
I'll oblige.
I'll oblige, Your Lordship.
May I please, Lordship? Lordship, we've already filed our reply, Lordship.
You joined us there.
Lordship.
Not been filed. You not filed it.
We have filed, Your Lordship.
See,
We have received a copy. Your
maybe it's
Lordship.
still in the registry, Your Lordship.
it's not been filed. Though MSS Dhar submits that the joint essence has been filed, the same not on record. Yes, this future we should go on.
Yes, sir.
Make sure this list up to 1 week. Yes.
I'll oblige, Lordship.
Oblige.
28.
Yes, my lord. This is a power matter, my lord. We were against
It's factuous. We'll dismiss it.
How, my lord? My lord, may I please place my written submissions, my lord, before the court?
No, we're not taking submission. We'll hear oral arguments only. Then submissions,
Okay, my lord.
Last time you were not here.
I was here, my lord.
You were here.
Yes, my lord. I was here and
What it means
I
now?
placed a judgment before my lord.
Cellular Operator Association of India versus
Yes,
Justice
yes, my lord.
Israni. Now regarding the EMR standards,
Give me the judgment. Yes, my lord.
absence of any law.
So, my lord, may I please show?
Now you're saying are you making a case high radiation fields?
Yes, my lord. My lord, there's a certain guidelines, my lord, as per the Meghalaya Building Bylaws 2021, my lord, if I may place this.
Business bylaws?
Building bylaws. Meghalaya Building Bylaws. I did not put. Where is it? If I may, my lord. I put. Section H. 1 minute, my lord. I'll just show you the relevant portion.
Now we'll see your prayer. Whether your prayer become redundant or still survive.
My lord, my prayer.
My prayer, only prayer number 9.
Yes, my lord.
To direct one to prevent overlapping high radiation fields, towers will be permitted. Certain radiation towers, high migratory bird traffic. There's two considerations we have to see now. We'll have another day.
My lord.
Don't hear our arguments, because otherwise there's nothing remains.
My lord,
we can't pass out.
There's certain. See, my lord, I cannot provide data. I am the petitioner, my lord. However, my lord, there are guidelines as per the Meghalaya Building Bylaws, my lord.
Due to paucity of time, it's a matter of 1 week.
Oblige, my lord.
30.
Yes.
May it please.
Yes, Mr. Sheikh.
Yes, Lordship. This is a case of cancellation of PDS license, Lordship. These are all connected matters.
What situation now?
Here, Lordship.
My lord, the committee is been formed by the state respondent, and under the chairmanship of Kaunbura, the food grains are distributed.
PDS. That is not affected, Lordship.
Yes, it's continued.
Committee now. What is the status now with regard to your cancellation?
My lord,
Termination has taken place, my lord.
My lord, new appointment has not been taken place. Lordship is still that.
Because in my case, my lord, 4 writ petitions, my lord has some
There is an order.
protection, my lord, because no third party right should be created, my lord, because in the first round of litigation, my lord, I was during the time of the inquiry, I approached this honorable court, and on the submission made by the State Council that no coercive action should be taken, then in the middle of the proceeding, my appointment was terminated. Then I was
Yeah, alternate remedy under the control order.
My lord, yes, my lord. That is the only one of the ground taken by the state respondent.
Will satisfy that part
Will
also.
satisfy, my lord, on that part, my lord.
My lord.
Then we'll have it at the second half.
Or my lordship may have next week, my lord. Today is Rakhi, therefore some function.
Yes. Then my lord, Monday, Tuesday.
After
Monday,
1 week,
Tuesday,
we are clogging that docket too much.
Much.
On the period the parties is after 1 week is after 1 week.
My.
You come prepared on alternate remedy.
Lordship. Well, we'll come prepared. There is judgment, my lord, by Jiva Chandra with regard to the statutory remedy, my lord, alternate remedy.
There are hundreds of judgments on a certain remedy.
Yes, yes. Yes. Deeply obliged, man.
37.
You have to finish within 10 minutes. Okay, start.
Lordship,
No one wants to come after 2 o'clock. So you finish within 10 minutes.
No, Lordship can come after 1 week or so, no problem. It is not urgent matter, Lordship.
It's a small matter, man, I can check.
Within 10 minutes can be finished.
Lordship.
That's because no one's willing. Once we see second half, everyone wants to run away. Why?
My lord, I'll take only 5 minutes, man, for my 5 minutes, my lord.
The matter is not urgent, my lord.
Okay,
Yes.
Yes, he wants to run away. So
Not running away, my lord.
this also after 2 weeks, yes.
Lordship.
On the party. No interim orders operating.
No.
That's all right. The pencil like this. Okay, now. Thank you.
Much less, Lordship.